Okie dokie. Pardon? Okay, no problem.
While he's getting set, oh,
Oh, yeah.
just administrative, I have witnesses for certain motions. Does the court have an idea about what time we're going to break today? I'm not asking for a particular time, just for my own planning.
I mean, I wasn't planning on going late, 5.
Unless we're in the middle of.
Yeah, I mean, unless 5, give or take where we are in the process.
I appreciate that, Judge. Thank
Yep.
you.
You guys got all week, so I don't feel the need to go late till we start to get close to the end. Okay, you ready, Mr. Forte? All right. All right, so, and these are witnesses that Mr. Hetzel's gonna love to hear from, right? Okay. Ms. Dixon, you were up here explaining to me how your indictment is good.
Yes, Judge. Let me, excuse me. If I could first correct myself, apologies. Yes, I'm a little tired and regardless, overt acts must be alleged for each and every one. I argued that to begin with and then kept using the wrong words. I'm referring to predicate acts. So correcting that, Judge, forgive me for that. So understanding that, I think the other question the court was asking me, I think, is how the defendant, for example, such as Mr. Liberto, knows based on our indictment that he is alleged, or how it is alleged that his overt act was part of the RICO conspiracy. And I'm just going back to those things, Judge, and I know I said it overly simplistically because that's what's in the indictment, because that's what he's charged with. But as far as how does he know, how is he put on notice? In the paragraph with Mr. Liberto, January 18th, 2023, reading from it, excuse me, page 81 of the indictment. Did Spencer Liberto did occupy the DeKalb forest with camouflage, camping gear, and living supplies. This was done to prevent the construction of Atlanta Public Safety Training Center. This was an overt act in furtherance of the conspiracy. And when you go back to the introduction paragraph, in paragraph B, again, it specifically says that the enterprise, Defend the Atlanta Forest, coordinated, advertised, and conducted direct action, and that direct action, not reading directly, but included certain crimes, including arson, destruction of property, attacks on people, and law enforcement officials, gun violence, etc. So when you read the indictment in its entirety, my contention is, or the state's contention is, it puts the defendants, all of them, on notice of exactly how, without not every detail, but that's not what's required, but they are on notice how we are saying their act, their overt act, tied into the conspiracy. So that said, Judge, moving back to, I think I had gone through and articulated and was at the point where I had articulated that the Dorsey case, as well as a plain reading of 5B, made that distinct, separate and distinct from 5A offenses, which bears on the interpretation. And specifically, Judge, I've already given you that cite, but that defendant argued that his indictment was not sufficient because those preparatory acts, or the acts involving murder, did not constitute offense, and that every predicate act must be a underlying criminal offense. That's been argued repeatedly in multiple motions. And in Dorsey, the court says Georgia's RICO statute, however, belies that claim. And then it goes on, as I mentioned earlier, to talk about 5B and how 5B is distinct because it does not require that the state allege or prove the full commission of an offense of one of the narrowed or narrower categories of offenses, but rather 5B says that for these certain crimes, arson and felony obstruction included, or felony arson and felony obstruction included, that it is sufficient for racketeering activity for the state to allege and later prove acts involving or acts or threats involving arson and obstruction. So all that to be said, going back to my hopefully otherwise sensible argument without misstating the law regarding overt acts. If we, under the Georgia RICO statute, if we excuse me.
So wait, so 5B
Yes.
says his overt act, and I'm sorry to put Mr. Liberto, he's just the example du jour.
Great example, Your Honor.
His act of going into the forest,
Mhm.
of occupying,
Yes,
attempt to occupy, that involved an act involving not the threat of murder, kidnapping, gambling, arson. It involved the threat of what?
let me clarify, Judge.
Because, okay, if you're going to say 5B, that's fine. This is a 5B, this is a racketeering activity under 5B. It's an act involving this, not necessarily the act itself. I understand that. That's your argument. But how is he supposed to know, is that involving murder, kidnapping, gambling, arson? Which one is it?
Let
How's
me
he supposed to know which one he's defending against?
Let me clarify. I am not saying that the overt act alleged against Mr. Liberto is in fact a predicate act. I am saying that I will say his overt act is not one of the predicate acts. It does not fall within the definition of 5A or 5B or domestic terrorism. And so, no, I'm not arguing that. I am arguing that as far as Mr. Liberto goes, that Mr. Liberto is put on notice as to the crime in which he's charged and the overt act that he is alleged to have participated in, and, which was your question, I think a question that I was trying to understand, and how that overt act is charged to be in connection or the nexus with the underlying criminal conspiracy and the enterprise. And my argument with regard to Mr. Liberto is that when the indictment alleges that he did this in the intro paragraph, that this enterprise did certain crimes in furtherance of, I'm just going to say it that way, or to get to their objective, okay? That talked about the nexus between the overt acts and each and the underlying purpose of the enterprise and the RICO type activity. So,
But if you've got the purpose in paragraph B
Yes.
is to prevent the construction of the Atlanta Police Public Safety Training Center, right?
that's part of it. I think it's essentially.
And Shadowbox Studios.
Yes,
And promote anarchist ideas.
that's part of that's part of what's alleged.
Okay, but Shadowbox Studios and APD Public Safety Training Center.
Yes.
And I hate to backpedal here, but doesn't that go back to their date range argument? Because nobody knew about Shadowbox or Public Safety Training Center in May of 2020.
Our argument.
And that is in the indictment.
Yes.
That is the stated purpose of this corrupt organization.
So yes, Judge, yes. And
So why are we predating that? Because they could not have been Shadowbox Studio, Public Safety Training Center, not a thing in May of 2020.
so
And like I said, I hate to backpedal.
No, you're fine. Of course, you're fine. Excuse me, Judge. No.
My job's to be curious.
My argument regarding that is that the enterprise, which had this goal of this trifold goal, and that the evidence will bear it out, but that the argument is that the conspiracy, notably, Judge, that the conspiracy, okay, existed from those dates. And let me make sure I've got I want to be technically accurate. Excuse me. Here we go. Where is it? Okay. Okay, so that they were associated with an enterprise. And you're, I think, saying, how can the enterprise with this purpose exist before the public announcement, before? What I will tell you is that the date range of that conspiracy is alleged based on the information that we obtained through evidence that we received and during the course of the investigation, whether it be statements of an alleged co-conspirator, which were not testimonial, so don't invoke the confrontation clause, but statements of a non-indicted or statements of a masked co-conspirator. We'll say it that way. We believe we know who it was, but regardless, statements of a masked co-conspirator. And again, Judge, under that logic, under their argument, the Network for Strong Communities, which was a core part of this whole thing, I mean, the record shows that they were incorporated in August of 2020. So my argument is that while the indictment alleges a date range, it then follows up with specific dates that actions occurred. And so as far as notice and all the case law they cited about notice, every single act charged as either predicate act or overt act has a specific date. So none of those cases are applicable to us.
Is Atlanta Forest the corrupt organization, or is Network for Strong Communities the corrupt organization?
Atlanta, in the indictment, it's defend the Atlanta Force. Network for Strong Communities, it's part and parcel of it. It gets very convoluted, but it's part and parcel.
I think that's exactly what the defense is telling me. And they're asking me, it's way too convoluted. I look at it, I can't see it.
Well, I'm not saying that the indictment can't be seen. I'm saying that the facts of the case are convoluted because, I mean, that's part of the intent. I won't get into that, but it is, we alleged the beginning of the conspiracy on that date based on evidence we received to include a unindicted co-conspirator's statement. That is part of why we included the date that we included. The specific overt acts are then alleged, and we're going to be restricted to allegations of those overt acts. However, Judge, I mean, under anybody's rational, just common sense approach, before the first overt act, an enterprise can exist. I mean, that's just common sense. I mean, it can exist before they first take an act or before they take an act that we charge. And so, yes, we have alleged that the enterprise and the conspiracy.
I agree with you.
Yes, okay.
An organization can exist.
Yes.
Now let's talk about the purpose. Okay?
Okay,
It can exist.
got it.
They could have, Atlanta Force could have been in existence since, I don't know, 1900. But Public Safety Training Center didn't come to existence then. I mean, how are they acting with a purpose for something that doesn't exist?
Judge,
Or
it can be in the planning stages of it. They may know it's coming. I mean, and Mr. Fowler may speak better to this, but.
well, I mean, he was up here saying, hey, that's when they heard about it.
Right,
And that's
yes.
when Mr. Hetzel is like, okay, fantastic. Let's hear it. Where is that in the indictment? Mr. Hetzel, was I wrong there?
clarify, I'm asking for the state to produce a witness or some other evidence that somehow gets us to May 25, 2020, instead of the first overt act listed, which is July 2020, instead of August 2020, when some organization incorporates, instead of September 2021, when the land swap happened.
You can go ahead. I
So
got it.
Judge, my first contention to all of that is, in order for us to need to put a witness on to explain why it can't be further delineated and narrowed, it has to be determined that it is insufficiently broad. And again, this is an indictment. It is about what the accusation is. I've explained to the court why we accused it the way we did, alleged it the way we did, which I don't think is even necessary. I mean, it is not an overbroad. We have to allege a pattern. Again, all of those cases regarding, and I haven't read the one that he provided earlier. I have not read that. But I did read a short blurb. The child crime cases, Judge, literally part of the rationale behind that is that a defendant charged with rape or incest, it's not permissible for the state to just generally alleged sort of this pattern of conduct, and that's not fair. That is the exact opposite of what the law requires for us to allege and prove RICO. RICO requires us to allege a time frame in which the conspiracy exists, because we must allege the pattern of racketeering activity. As to that one case whose name I do not remember, I pulled it up. I didn't read it in full, but I can tell you in the holding section, one of the things it said was it's not valid because the 43 predicate acts or the 43 separate acts there was no date given. That's the exact opposite of what we've got here. So we have a date range that we say in our indictment. If I'm not saying what's going to happen at trial, but we have accused these defendants of participating and conspiring in this enterprise, or while associated with this enterprise, in RICO activity between these two dates, and then allege specific instances of overt act and predicate acts with specificity and dates. In that scenario, we don't get to put on a witness because they haven't satisfied the burden that we would need to narrow it. And so that's the state's position with regard to that. Now, moving back, and I understand why it was a little discombobulating when I started back in on the indictment. However, let me go back, Judge, and I was before the break talking about how the indictment alleges racketeering activity, or a pattern of racketeering activity. And I started off by saying all we have to do is sufficiently allege a single incident of domestic terrorism to establish a pattern of racketeering activity. In section 2 of our indictment, in paragraph 152 of count 1, we allege that on January 21st, 2023, Naja Geyer, Madeline Fiola, Emily Murphy, Francis Carroll, and Ivan Ferguson did join the Night of Rage in Atlanta and cause arson and property damage, and thereby committed the offense of domestic terrorism. However, going back to the Sanders case, Judge, which talked about compound crimes, conspiracy being a compound crime, that you can look to the other counts for the rest of the details to support your predicate act offense and whether they've been put on notice. And corresponding count 2 of the indictment further sets forth all of the elements of that exact same domestic terrorism. It relates back to it. It follows the language, same date, same individuals involved. So there and then, under the law, whether people think it should be enough or not, but under the law, we have alleged that as an overt act, these participants, these 4 on this date, participated in domestic terrorism, and then in count 2, as allowed by Sanders and a lot of other cases too, but Sanders in 2022, then we then supply the necessary factual specificity, or alleged specifications or specificity to the domestic terrorism and how they committed it. So that's one. So right there, Judge, we've established a pattern of racketeering activity. Then you get to, did we establish a pattern of racketeering activity under 16-14-3-4A, which is the subsection that says at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interpreted by are interrelated by distinguishing characteristics and are not isolated incidents. And then it goes on to give you the time boundaries of when those can occur. Racketeering activity then gets defined. So what are incidents of racketeering activity? And this is where I was talking earlier. Racketeering activity includes 2 different things. One is the commission, attempt to commission, et cetera, of enumerated offenses, and it's like through 43. And it's not just 43 offenses, it's 43 categories of offenses. So for example, assault under the chapter and article, and so it would be any of those assaults. But 43 categories of offenses. Or B, which is what I was talking to you earlier about the fact that if the court, the indictment can allege acts or threats involving felony arson and felony obstruction of justice. And so if we have then, within the entirety of this indictment, alleged either, we have already argued that we allege domestic terrorism, so we're done with pattern of racketeering activity. However, if the court deems otherwise, then have we done it through one of those 43 categorical crimes under A, which would have to include all of the elements of those underlying offenses because they are, in fact, the commission of an offense. Or under B, which is allegations of acts or threats involving the arson and the felony obstruction. So, and I quoted that case to you already, Judge, so we won't reiterate. So going to the specifics, and I'm going to start with A, which is the racketeering activity that is in and of itself a crime. And the state asserts to the court that the indictment in its entirety sets out multiple allegations that are sufficient to establish an assault. And this goes back to the beginning, Judge. I quoted, 2 seconds. I think it's still Sanders. Yes, Sanders v. State, where it says the indictment must, one of the 3 ways is if the indictment alleges elsewhere facts showing how the compound offense was committed. So one of those 3 ways, either in count 1, setting out all the elements, and the elements are all set out in count in the entirety of the indictment, or we've alleged sufficient facts to establish the elements essentially of the compound crime. So starting with assault, the state would assert to the court that the indictment in its recitation of 225 overt acts that specifically the indictment says include racketeering activities, that we have alleged assault in paragraph 72, in which it gives a certain date, says specific individuals, Abigail Skapyak, Philip Flagg, Madeline Kodat, Brooke Quartermont, Mariana Hoyt-Lange, and Anna Gypsy Lee, and 2 unindicted co-conspirators did throw Molotov cocktails and glass bottles at police officers. 2, the state asserts that we have alleged an aggravated assault in paragraph 110. On November 8th, 2022, Abigail Skapyak did provide information to a masked unknown individual that held Richard Porter, a metal scrapper, at gunpoint in Encroachment Park, thus committing aggravated assault against Richard Porter. The 3rd example of an assault is paragraph 116 on
She provided information.
Information to the person, yes.
What time of day it was, what kind of information? She provided information to somebody committing a crime.
So somebody who held him at gunpoint, yes.
Okay. And what kind of information was that?
It's not alleged in the indictment. I mean, I can tell you that, and it's in the discovery, but it's not alleged in the indictment.
So how is Ms. Skapiak supposed to look at number 110 and go, how do I prepare for that? I provided information.
I mean, I think she has to know what she needs to defend against, and I think it puts her on notice that what she needs to defend against.
Provided
And
information to wit, the information provided to an unknown individual.
it could be more specific. I'm not arguing with you about that. Our contention is that it is sufficient to put them on notice and sufficient to plead a predicate act.
You allege it as an overt act, not a predicate act.
Well, it's both, and it's alleged as both. It's, I mean,
This is an overt act in furtherance of the conspiracy,
yes, but at the heading,
thus committing an aggravated assault.
yes, but at the forefront of those 225 paragraphs in part 2, it says the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below.
Then you're going back to paragraph B. Is that where you are?
Part 2, no, it's the beginning. Excuse me, Judge. Let me pull up the indictment real quick so I can make sure that I'm directing you to the right portion. Do you have the indictment pulled up?
I've got it pulled up. Part 2 of the indictment.
It should be right above the beginning of the recitation of the 225. It's part 2.
Page 49.
Thank you.
Defendants committed overt acts to affect the object of the conspiracy, which includes sets of racketeering activity as described below, acts of racketeering activity as described below.
Yes.
Okay.
And I think you're getting to something that will be covered in a later argument. All right, so Judge, then we move to, I think I left off with paragraph 116 on December 13th, 2022. And I'm going to just kind of abbreviate instead of exactly quoting, but Carol, Tilbury, Olson, all named defendants in this indictment, did throw rocks, a bottle, shoot fireworks at firefighters and EMTs. Paragraph 121 is another simple assault. December 13th, 2022, Serena Hertel did cut a rope in an attempt to cause an arborist to fall during climbing. This is an overt act in furtherance of the conspiracy, which is at the end of every one of them because it's required for us to allege that they overt acts are in furtherance. Fifth incident of assault or aggravated assault alleged in the indictment is paragraph 124. December 14th, 2022, Ariel Ebaugh did approach to cab law enforcement with a rifle, knives, and a pistol in a threatening manner in an attempt to intimidate the officers, thus committing an aggravated assault against cab law enforcement. So right there, based on that, our allegation or our assertion to the court is that first and foremost, we established domestic terrorism. We supplied the necessary elements and details in count 2, which is completely permissible under the law of the state, and because it's a compound crime, and that we have also in these predicate acts set forth the necessary facts to allege either assault or aggravated assault. Then judge number 27 or the 27th, because it's not number 27, it's like XXLL, whatever it may be. The 27th category or list of offenses under 5A that can be alleged as racketeering activity is influencing a witness. And the elements of that are it shall be unlawful for any person knowingly to use intimidation, physical force, or threats to persuade another person by means of corruption or attempt to do so, with the intent, B, to cause or induce any person to withhold testimony or a record or a record, document, or other object from an official proceeding. And that's obviously not the entire statute, Judge. I have sort of culled it down to include only the portions of the statute that we assert are relevant to our indictment. And so the state asserts to the court that the indictment contains 41 separate allegations of co-conspirators using threats with the intent to cause and induce construction officials to withhold records and documents or testimony in official proceeding. Those paragraphs are 5 and 6, 8 through 11, 13 through 15, 17 through 24, 32 through 37, 71, 103, 125, 127, 128, 130, 133, 134, 149 through 151, and 158 through 164. Each one of those paragraphs sets out every element necessary to prove and charge influencing a witness under the section of the statute that I read to you earlier. I know that there was an argument from somebody, I'll just go ahead and address it, that we did not allege that there was, and there in fact wasn't a pending proceeding, and I'll provide the statute to you, but the statute just directly states that there is no burden to prove, much less plead, that there is an ongoing pending proceeding. So based on that, we allege those things, Judge. It's according to the state. We have alleged domestic terrorism. So check off pattern of activity being alleged, pattern of racketeering activity being alleged. We have alleged multiple counts. I think it was 20 something counts of assault, either aggravated or simple. But then we alleged 41 distinct allegations of influencing a witness in the paragraphs that I referenced to you before. So those are our 5A offenses in which we assert that we have met the burden through Sanders and the Sanders standard. I don't remember if it's Sanders v. State. Anyway, the Sanders standard that all of the necessary elements that are provided to the defense through either recitation of the statutory language, or recitation of facts that would support the elements of the offense or prove the elements of the offense. However, we're not limited to those 5A offenses because of subsection 5B. And again, I read to you from the case, it is a direct Supreme Court of Georgia case that says 5B, racketeering activity, it does not equal a criminal offense, rejects that notion and says it's different. You don't have to prove that they committed murder, arson, obstruction. Those things are under 5A. But it provides a different and additional way for the state to allege and later prove racketeering activity through acts or threats involving felony arson and felony obstruction. So where do we allege those, Judge? Our contention is that acts or threats involving arson are alleged in paragraph 1, where we allege that a Molotov cocktail was thrown at Georgia State Patrol headquarters, and that is an act or a threat involving arson. Not that we've laid out the offense of arson, but it's that we have alleged an act or a threat involving arson. Paragraph 130 is an act or threat involving arson when it alleges on or about January 1st, 2023, Kautz, McLean, and Patterson. And again, I'm summarizing a little bit. They published these scenes blogs post claiming responsibility for an arson of a bank and thereby made threats against construction officials committed and influencing a witness, the rest of that paragraph. So we've alleged acts involving an arson when they used, threats. We've alleged threats involving arson when we allege that those 3 individuals made a post and claimed credit for an arson and then used that arson to threaten and intimidate witnesses. That's our allegation.
I'm looking at 161093, influencing witnesses. Person who, with intent to deter a witness from testifying freely, fully, truthfully, to any matter pending in any court,
Yes.
in any administrative proceeding, or before a grand jury, communicates directly or indirectly to such witness any threat of injury or damage to the person, property, or employment of the witness, or to the person, property, or employment of any relative or associate of the witness, or who offers or delivers any benefit, reward. The first part was the stick. Now they're getting to the carrot part of it. Okay. And you're saying publishing this stuff was an indirect communication.
Judge, I'm saying that it fits under, if you will give me 2 seconds. 93. There it is. That it fits under, it shall be unlawful for any person to knowingly use intimidation, physical force, or threats to persuade another person by means of corruption or to attempt to do so, or to engage in misleading conducts towards another person with the intent to influence, delay, or prevent the testimony of the person in an official proceeding. B, and this is what we've alleged, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And official proceeding is not just is defined, and it is not limited to court cases. I'm trying to find, there it is. In 3A, it includes hearing or trial conducted by the court of the state or its, okay, sorry, I'll just read. Any hearing or trial conducted by a court of the state or its political subdivisions, a grand jury, or an agency of the executive, legislative, or judicial branches of government of this state or its political subdivisions and authorities. So it does not have to be a court case. If there is a hearing in an administrative hearing that falls within those branches of government, and that type of hearing is defined in that statute, and somebody does something and threatens with the requisite intent, and that's what we've alleged in this.
Okay.
So we've alleged that's one of the ways, but that they use these threats to intimidate and influence construction officials from doing the elements of the crime. I'm not going to read it all again. To prevent them from providing documents, et cetera, in an official proceeding. Now, let's see, where was I? All right. Yes, acts involving arson, paragraph 152, on or about January 21st, 2023, Geyer, Fiola, Murphy, Carroll, and Ferguson, and this is that paragraph we read earlier, did join the night of rage and caused arson and property damage and thereby committed the offense of domestic terrorism. So at a minimum, that is not only directing them to the count 2, but it is also an act involving arson. Paragraph 153, on or about January 21st of 2023, Ivan Ferguson and Naja Geyer rode together in the night of rage inside a truck with a gas can and camping gear and a climbing gear. I withdraw that, Judge. I don't think it's clear enough as I read it. I don't think that's clearly enough that it is involving. Now, it is later charged as part of the arson. And so you can argue that it is that paragraph in conjunction with count 2 puts them on notice that it is a act involving arson. However, I will go with count 2 as a definite way of putting them on notice and providing them with all the necessary details that they have been charged with an act involving arson.
Is not 153 and 154 the exact same sentence?
Let me check, Judge. Yes, I do believe there's one that's repeated. I do believe there's a duplicate, Judge. Let me check though, if you don't mind. I may have just a moment. 153. I think that's correct. I think I noticed that. They're duplicative, Judge. So we can agree that one of those would be redacted or struck. All right, and then Judge, in paragraph 155, on the same day, Carol is alleged to possess a lighter and accelerant while attempting to break into 191 Peachtree Street in Atlanta, and did commit the offense of domestic terrorism, referring to count 2, of course, where all the rest of the details. However, that plus count 2 definitely puts him on notice, because count 2 explains that he was doing so in pursuit or while attempting to commit an arson. So that puts him on notice that he is thereby charged with the predicate act involving arson. Number 6 in 24 different times, paragraphs 194 through 217 allege that the different co-conspirators, so everyone is, it doesn't allege that vaguely. It says on or about March 5th, 2023, so-and-so. And so there's 62, or so, not 62, it's however many were there. Each one of the defendants are then named, and it says they did join an organized mob and succeed in overwhelming police force, thereby aiding and abetting in the offense of arson and domestic terrorism in an attempt to occupy the force and prevent the building of Atlanta Public Safety Training Center. That each one of those paragraphs, and then it also has the overt act language.
The arson and domestic terrorism that happened back in January?
No.
Okay.
No, sir. It's a separate date. It's a separate incident. This is, well, you don't need me to get into all the facts. This was the March 5th incident where they burned a bunch of stuff, and set things on fire. And, anyway, so that specific allegation, definitely 24 separate times against 24 separate defendants, alleges that each one of those 24 co-conspirators, as alleged in the indictment, committed acts involving arson. So those are so that's 29, I believe, Judge, and I'm not the best at math, but 29 acts involving arson have been alleged. Then we get to acts or threats involving felony obstruction. We've got 27 of those alleged, Judge. That's paragraphs 119 through 121, and that's December 13th. Did issue a call to action on Instagram for forest defenders to deliver a physical response to prevent her arrest. So we allege that is sufficient to put them on notice that they are charged with a act or a threat involving felony obstruction. 120, it's the same date, same person, attached a wooden board with metal spikes to a treehouse to prevent law enforcement from reaching the treehouse. 121, the same person on the same date, cut a rope in an attempt to cause an arborist to fall during climbing. And then in 24 times, paragraphs 170 through 193, similar to the other ones I referenced with the arson, but these paragraphs say and allege that on or about March 5th, and then there's 24 different of these co-conspirators named individually in each one of these paragraphs, that person did join an organized mob of individuals designed to overwhelm police in the police force in an attempt to occupy DeKalb Forest and cause property damage. That particular, all of those, the state alleges, allege sufficient facts that would support a predicate act of act or threat involving felony obstruction of justice, Judge. So in summation, the allegation is we did not allege predicate acts. Some of them say no acts of racketeering activity. Some of them say no pattern of racketeering activity. I'm addressing whether we alleged pattern of racketeering activity through racketeering acts. And in summation, Judge, we have alleged 27 allegations of threats involving felony obstruction, 29 allegations of acts or threats involving arson, 41 allegations, I'll slow down, of influencing a witness, 3 allegations of simple assault, 2 allegations of aggravated assault, paragraphs 155 and 156, in correspondence or corresponding to count 2, allege the domestic terrorism. Yeah, that's all we had to do. One count, one sufficient charge of domestic terrorism. And then paragraph 152 puts defendant on notice of the racketeering activity crimes of domestic terrorism and attempted arson with corresponding counts 2 and 3. That then, so you've got 2 is domestic terrorism, 3 is arson, and count 152 puts them on notice that they are charged with conduct that then is arson or domestic terrorism, and that those offenses are later defined in counts 2 and 3, which is allowed under the Sanders case and many other cases. So Judge, as far as the arguments of Mr. Sanders, I don't think I will have to take up the court's time because many other defendants argue the same thing, and I believe that I have covered what our position is with regard to that. And again, Judge, so in essence, in response, this is not targeting or subjecting these defendants to illegal prosecution under the First Amendment under any way. And the state has sufficiently alleged for an indictment that the elements of RICO conspiracy, including a pattern of racketeering activity and the specific racketeering acts or racketeering activity that support that. All right. Thank you for your time, Judge. Do you have any questions?
Not right now. Nope.
Thank you.
Do you want to follow that back up? It's y'all's motion. I'm going to take that as a yes.
All right. Well, a lot of issues that she raised, some of which, as I told you before, we got no briefing from the prosecution before this hearing today. So none of the cases they've cited, nothing that they've cited here today was ever previewed with the defense over the last 2 years. So it makes it a little difficult to reply to some of these. But I'm going to do the best I can. First of all, with regard to the issue of the impropriety of the introductory language, the 25 pages of the, as you put it, the Aleppo allegations, this is not a case like Mr. Fowler referred to in the Second Circuit case involving a prosecution of the Genovese crime family. Of course, there are going to be allegations about the history of the Genovese crime family, just like there can be allegations about the history of the actual enterprise in this case, as opposed to going back literally hundreds of years with, allegations about the history of anarchism and violent anarchism. There's a world of difference between alleging the background of the Genovese crime family in a Genovese crime family prosecution and allegations about the history of the philosophy of anarchism in the world. Second of all, the allegations in our case include all kinds of allegations from taped interviews of people who are masked and who make allegations that are never identified. And we have no idea who these people are. People making violent allegations, violent suggestions, supposedly to members of the enterprise here. A clear violation of the Confrontation Clause, no matter how you dress it up. They can, whatever Mr. Fowler claims about where they derived this information from, I don't know, I have no idea because it doesn't allege where they found it or gathered it. So the idea that they can present to the jury, either in the indictment or even in evidence, a masked person reading a script saying we should kill more policemen would never be tolerated in an American courtroom. So, Mr. Fowler's closing remarks where he says, we think this does go to the jury. The entire indictment goes to the jury, including this language. And these allegations by, unidentified people is a clear violation of the Confrontation Clause and due process. With regard to the suggestion that we should just simply strike it, that we could use the vehicle of a motion to strike surplusage, that is actually not done very often in Georgia. It's done frequently, much more frequently in federal court, But in Georgia, it tends to be done with as an errant word or an alias that didn't, we're going to call some guy, murdering Joe or something. We can strike that kind of surplusage. We're talking about striking 25 pages of this indictment. That's what we're talking about, is the only remedy, which we believe is more akin to a special demurrer, as opposed to, dressing up the indictment a little bit or cleaning it up a little bit through a motion for surplusage. So we stand on the position that it is a remedy, that the remedy we seek, which is dismissal of the entire indictment, go to a grand jury without polluting the grand jury with this information and inducing the grand jury, because of these masked people, you can assume that all these defendants out here are murderers and that they all advocate for murder and killing policemen, which is what the introductory language suggests with these masked people who are giving speeches. The only possible remedy the only reasonable remedy is to dismiss the indictment, grant the special demurrer with regard to that, and let the grand jury return an indictment which is more befitting a courtroom in this county and in this state. With regard to the demurrers, and I'll start with where Ms. Dixon finished, which was these allegations dealing with intimidation of witnesses. If you look at the overt acts that we're dealing with here, time and time again, they talk about my clients, as well as many of the other clients, engaging in some kind of conduct to affect an official proceeding. Ms. Dixon's correct. It doesn't have to be a pending proceeding, but it has to be an official proceeding. And they've never identified, nowhere in this indictment does it allege what official proceeding was supposedly going to be impacted. And there's nothing in either the federal intimidation statutes, the obstruction statutes, or the state statutes that say you can just allege an official proceeding and we'll just let the jury decide. Because we sure have no clue what they're talking about. We have no clue what the prosecution's intending to present before the grand jury, before the trial jury, as to what official proceeding could possibly be envisioned by the defendants who were engaged in this conduct. And given their argument today, I will give you a case, a recent case that's not in my case. The case is State versus Eastman. This is the Trump case in which we argued to Judge McAfee exactly this issue, that there was a solicitation to the legislature. I don't know if you've ever read the Trump indictment, but the defendants are alleged to have solicited legislators to violate the Constitution by uncertifying the election. Right? That's the allegation against the Trump co-conspirators. And we argued to Judge McAfee that the indictment was defective because it didn't say what part of the Constitution do you claim we were violating. And he agreed, and the Georgia Court of Appeals agreed. And the case is State versus Eastman. The citation is 374 Georgia Appeals 484 this year. That's Judge McAfee in the trial court last year and the Georgia Court of Appeals this year. 374 Georgia Appeals 484, granting a special demurrer, dismissing all those counts of the indictment. There were many counts of the indictment dismissed. Agreeing with our argument that you've got to be specific when you're talking about, what part of the Constitution you were soliciting the legislators to violate. Clearly analogous to the argument we're making here is you have to tell us what official proceeding you're claiming we were trying to obstruct. Doesn't have to be pending, it can be envisioned, but at least we have to have been thinking of an official proceeding, and they have to identify what kind of official proceeding and what specifically official proceeding we were envisioning. With regard to, Mr. Garland's going to be arguing either next, or I'm not quite sure what the order of proof is going to be here, but he's going through a lot of the special demurrers that surely apply to my three defendants. He's representing someone else. It's just count after count after count where we're having to guess what the prosecution is going to try to prove, which is exactly what the office of a special demurrer is. And the prosecution is wrong when they say, you already contested this. Just look at the discovery and you can find out. Federal courts, sometimes they allow that. They allow it with a bill of particulars. We don't have bill of particulars in Fulton County Superior Court or in courts of Georgia. They have to allege the facts that are needed, not just the law that is violated. And the Jackson case that we put in our brief, 301 Georgia 137, in our brief, explains, the Georgia Supreme Court explains that a special demurrer can demand facts that allow us to prepare a defense. And I'll go back to the Scenes blog allegations again. And Mr. Fowler says, oh, it's as clear as could be. We've identified every fact you could possibly want to know. You authored something, and then describes the supposed statement that we authored, and it ended up on some blog site somewhere. Dozens of counts, many of them dealing with the official proceeding claim as well. And yet they never say how we supposedly authored it or who authored it, because each of those counts says some undefined number of unindicted co-conspirators and Marlon Counts and Adele McClain and Savannah Patterson all authored something that ended on a blog post. We have no idea what the actual allegation is. We could find the blog post. It doesn't have anybody's name on it. We don't know who the unindicted co-conspirators are. Apparently they don't either. We don't even know categorically who the unindicted co-conspirators are. There's no defense we can do. We could have started the trial the day after the indictment was returned, because we knew as much then as we know today. And the prosecution also says, you can find it in the discovery. You can't find it in the discovery. I went to Mr. Fowler's office. Me and Mr. McDermott went to Mr. Fowler's office. Would you tell us how you have facts that show that either Counts or McClain or Patterson authored these things in the Scenes blog? I told you this morning. They gave us one piece of paper that has the Atlanta Solidarity Fund and Scenes blog on the same page. We don't even know who authored that page or what it was. It was from what they call a zine. But nobody knows who authored those or it was a fundraiser. We have no idea that has anything to do at all with proof that we authored it. And the Jackson case says where you need facts to prepare a defense, facts should be supplied. And just saying you authored it without giving us any information whatsoever requires that those predicate acts be dismissed, that a special demurrer be granted. And I was going to go through a number of these overt acts, but I think Mr. Gorham's going to do that and shows all the special demurrers that are needed. So if I could just defer to him. Plus, most of them have nothing to do with these four defendants. So it's,
You might fight that another day then.
some of them may, and I'm concerned that I may not understand the proper protocol here. I mean, there are many, many issues dealing with our three clients. I say my law firm's three clients that have nothing to do with them. And I'm sure you don't want to hear about, for example, the motion to suppress is still pending.
Mhm.
Has nothing to do with these four people. It's been sitting there for 2 years now. We have the whole filter team issues that we're working through at least, and close, but not done, resolving. But just dealing with the demurrer, if I can. The other thing I would point out, I want to talk just briefly about the Dorsey case. This is Sheriff Dorsey. You remember Sheriff Dorsey was alleged to have assassinated or arranged for the assassination of Derwin Brown in DeKalb County. And I represented Sheriff Dorsey, unfortunately, because I lost that case that Ms. Dixon is talking a lot about. And it does have troubling language about the definition. My definition is troubling language about the definition of a racketeering act. The structure of the statute is, and Ms. Dixon talked about this a little bit, is there's a list of 43 specific generic crimes in Georgia, including homicides, everything in chapter, 1651, various sex offenses, 16.6. If you look at section 5 of 1614 whatever, there's 3. Georgia code sections. And then if you look at 5B, it says any crime in any state involving murder, arson, and the whole list. It is clear from the legislation that what the intention was to bring in the laws of all 50 states, because RICO allows you to prosecute for crimes that occurred outside the venue. So first they identify all the Georgia crimes, including murder, including arson, including intimidating witnesses. That's all in A. And then it says, and in any state, crimes involving arson, murder, and intimidation. Because they're trying to bring in reality, another 49 states' laws in Section B.
Don't forget the territories.
And DC. And,
Guam.
huh?
Guam.
That's right, Greenland?
Right?
No?
Not yet.
Not yet. So, but listen, I'm gonna be honest, the Supreme Court didn't agree with this. And the Supreme Court agreed with Ms. Dixon. And again, I suppose we're gonna have to honor that here. They did say, when the statute said, and any state, even though it is abundantly clear they're trying to bring in 49 states,
It meant Georgia too.
we're one of the 50.
Yep.
So the question is how to limit Dorsey somehow to make sense. Because why would you say you have to prove a predicate act murder, arson, and then say, or any act involving murder? It's completely duplicative. There's no reason to have had Section A at all if you're going to say any act involving murder. It doesn't say any overt act in B. And in Dorsey, they never defined what they meant by an act involving. We know what the legislature meant. It meant the crimes in Maryland involving murder, the crimes in Kentucky involving murder, the crimes in South Carolina and Alabama, because they didn't want to have to go through every code section of every state. So, but the point is that has nothing to do with the demurrers that we have filed, because none of my clients are charged with, my clients, my law firm's clients, none of them are alleged to have violated an act involving murder or an act involving any of these other code sections that they're alleging. Nor do the predicate acts say that that's what they're relying on, a 5B allegation. As she says, calls them 5B claims. None of them say that. We're just left to guess. What is the predicate? What are we defending here?
Does the indictment have to delineate between 5A and 5B? I mean,
I would think so. They have to say, they can't just, they don't give us many facts, and then they don't give us the appropriate code section. That's what Jackson says. Jackson even says you shouldn't even rely just on code section. It should be code section plus element plus facts. And if it's obvious, and sometimes it is obvious, like in Sanders with some of the counts were thrown out in Sanders. I mean, Sanders has some counts that survived the Supreme Court, and other counts, I think Judge Bethel wrote the decision, other counts where he said, you allege they violated the Controlled Substances Act. You didn't say what drug. Well, I think under their analysis here today, you don't really have to do that. Just say VGCSA. But Judge Bethel said, no, you got to be precise. You got to be precise, exactly what drug. And that's for a solicitation count, where it's the predicate offense for a solicitation count. Were you with me? The defendant asked someone else to sell him some methamphetamines, and the indictment said, you solicited someone to sell
a drug.
drugs. And Bethel said, and in violation of VGCSA, and Justice Bethel said, that's not enough. You got to identify the specific drug. Well, that's like the official proceeding in these counts. You got to identify the official proceeding. You have to be precise so we can at least prepare a defense. I'm back to surplusage for 1 second. Mr. Fowler says one of the reasons we can put it in is because it came out of their own language or their own mouths, the defendants. I seriously doubt that. I seriously doubt the accuracy of what he said there, not intentionally, but is he claiming that they have one of the defendants reciting 25 pages worth of the history of anarchism somewhere? We certainly haven't seen that in the discovery. And so I think what he's doing is he's saying we've got these masked people talking. So we're not going to tell you who said it. We're not going to tell the jury who said it. Just someone wearing a mask said, you know, during the night of rage or day of rage, we ought to kill some cops. And says, well, that's why it's in the indictment, because some masked person said it. And then he said, well, maybe it came out of books or articles. Well, let me remind him of the First Amendment and you know, the Anarchist Cookbook. A lot of people have got a copy of the Anarchist Cookbook. I bet you've got a copy of the Anarchist Cookbook in your library. But nobody would say that you're making bombs, you know, or that you believe in bomb making, or that you advocate bomb making. And we all have books in our library that we don't actually advocate for. I mean, criminal defense lawyers have all kinds of books in their libraries about the crimes that we defend against, our clients who were charged, you know, and if you may remember from our motion to suppress, the types of materials they seized from our client's house, the voluminous amount of books and magazines and pamphlets. Some of them were in fact written at the beginning of the century, and they're claiming they're going to use that in our trial. So strike the surplusage or not, they plan to put it in anyways because it was in Marlin's library. We quote 100 cases to you saying you can't put the Anarchist Cookbook in evidence. It's the same as the, you know, rap music cases. So I'm going to defer to Mr. Garland if I can, and with all respect to these four folks, when their special demurrer gets raised, I think he's been invited to deal with those facts. But we maintain general demurrer should be granted in this case because of the various flaws with the indictment. Can you imagine, can I just finish with this? Can you imagine trying to instruct the jury consistent with everything that Ms. Dixon just said for the last 2 or 3 hours? Can you imagine trying to explain to a jury the way this indictment is framed? The intricacies of the verdict, either guilty or not guilty on count one. How are they going to do that with this indictment?
I would look forward to reading the proposed jury charges provided by the parties.
Well, we have tried actually to start working on that. It is impossible. It is impossible. Okay. I mean, you've read the indictment, right? You've read the motions, you've read the demurrers, you certainly know the statute. Can you imagine trying to explain to a jury how, take my clients who've never set foot in the forest, who paid for people, who arranged for the payment, they didn't pay, arranged for payment for people for hot dogs, veggie dogs actually. That is or is not an overt act that you can use to hold them responsible, hold my clients responsible because they're paying for food. You about to ask me a question or about to be frustrated?
No. I was just about to make a Godfather reference. Marlon Brando never pulled the trigger. Marlon Brando never went on the scene.
Yeah.
Kind of the point.
Well, we don't know about that, but but
That's kind of what RICO was originally designed for. Was it not?
well, it was, it wasn't necessarily for Marlon Brando. It was for racketeering. It was for organized crime families who have a vast array of crimes being committed by a vast array of people in various jurisdictions.
And it's how to get those people that manage to keep their hands clean.
Oh, I don't know about that. It's always been that the ringleader is certainly subject to being prosecuted. There's nothing about RICO that makes that unusual. There's nothing about RICO that says go after the kingpin. I mean, it's the same level of proof as before RICO was enacted. But I'm sorry, you got me off track a little bit. The fact that my clients didn't go to the forest is certainly an issue here. They're not charged with trespassing. They're not charged with.
Michael didn't get in the boat with Fredo.
Say it again.
Michael didn't get in the boat with Fredo.
I assume there's cement shoes somewhere in that, right?
You've never seen The Godfather, sir?
Many times. But, all right.
Fredo doesn't make it out of the boat. Let's just leave it that way.
Okay. Thank you.
Okay. 1:30, where are we? We were in this, I mean, are we?
Which is the motion that Mr. Garland is arguing against.
Where are we?
We're at number 3 on the list, which is the motion Mr. Garland is arguing.
Or number 3.
Arguing the other issue.
Number 3 is the general and special demurs to count 1 for insufficiency. And then number 4, if we get to it today, is the lack of prosecutorial authority.
Yes, Your Honor, and for both 3 and 4, we've estimated roughly an hour each. Mr. Hall will be arguing number 4.
Yeah, I think you guys estimated an hour on 1 and 2 also, so. You guys keep time about as well as other
And
lawyers.
Your Honor, if Marsicano could go after Mr. Garland as part of number 3, just to clarify the record.
We'll cross that bridge when we get there.
Thank you, Judge.
Mr. Garland,
Good afternoon, Your Honor.
indeed,
You hanging in there?
always.
All right, this demur raises both general and special demurs, but I'm going to focus on the special demur aspect of it. And when addressing a special demur, some of this argument has been couched in terms of general demurs. Has the state alleged enough to pass a general demur? But I want you to focus on the requirements of the special demur here. The court's got to apply the rule that a defendant who timely demurs is entitled to an indictment perfect in form and substance. And this isn't a horseshoes kind of test, like close enough is good enough. If the state wants to put people in jeopardy of losing their liberty, at minimum, the indictment must be perfect. And I'm going to start with a topic that's already been touched upon, but which is the indictment's failure to adequately allege the underlying acts of racketeering. As has been discussed.
Can we talk about that perfection real quick? I'm gonna go back and quote Kimbrough again. To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. Just in that case, they hold that the sparse allegations in that indictment would say nothing at all about the nature of the connection are insufficient to enable the defendants to prepare for trial. So yes, they use the word perfection and then they qualify it immediately.
Yeah, and I would suggest that the pages and pages of detail in this case, Your Honor,
This sucker's 109 pages long.
are anything but.
Okay.
So let's start with these underlying acts of racketeering that the state has to prove in order to establish their case. You know, we've talked about how it's a compound offense, right? You got to prove the RICO and you've got to prove the underlying racketeering act, which are themselves crimes. And the Supreme Court has said the indictment must clearly set forth the elements of those underlying compound crimes and the facts that support them. This indictment may do that in a few occasions, but the state has repeatedly alluded to and argued there are a variety of other spots in the indictment that satisfy the racketeering act proof that don't contain the elements, that don't contain an adequate application of the facts of those
Let me
elements.
ask you this. Are you going to make a differentiation between predicate acts and overt acts?
Yes, yeah. I'm specifically at this point in my argument talking about those acts of racketeering, what we call the predicate acts,
Okay.
right? Those things they have to prove as part of establishing,
That are criminal acts standing on their own,
yeah, that the conspiracy engaged in,
that fit within 5A or 5B.
right? Either the domestic terrorism or 2 other acts of racketeering activity or the act involving that was discussed extensively before. I'm talking about those.
Okay. And
Those are compound crimes that must be adequately alleged, and the courts have told us that. And as Mr. Samuel noted, the indictment doesn't identify any act of racketeering other than to say some undefined number included within the overt acts. There's nowhere in this indictment that says this is a racketeering act.
none of them say predicate act. They all say overt act.
And it says any of these the racketeering acts are included somewhere in these overt acts. It never identifies one racketeering act. We are left to guess. We are left unable to intelligently prepare
The
our
defendants-
defense.
The defendants committed overt acts. This is the beginning of part 2 on page 49 of the indictment. The defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. And then all 225 say they're overt acts. None of them distinguish themselves as acts of racketeering. That's your argument?
We are left to guess, Your Honor.
Okay.
We are unable to intelligently prepare our defense as the law requires us.
And I
to
think
be
Ms.
able to.
Dixon was saying, some of them set forth in their facts. Let's see. I'm going to go with, on page 84, overt act 152, 153, which is talking about arson. 155 specifically mentions did commit the offense of domestic terrorism. Would that not put a defendant on notice that that's a racketeering act?
Well, I mean, I can talk to you about those.
If it's talking about domestic terrorism and it actually states domestic terrorism or arson, both of which would qualify as racketeering acts, for the purposes of getting to the magic number of 2, does that not put you guys on notice?
Well, it puts us on notice that they're claiming it's an act of domestic terrorism or arson. It does not put us on notice whether they intend to rely on that or whether there will be proof that that can be one of the acts of racketeering. If you look at this indictment and you listen to the argument of counsel, there is an unlimited possibility of possible racketeering acts. We are left to go through the indictment and try to figure out which ones they are. Now, as Your Honor points out, where they use the words domestic terrorism, where they use the words arson, that's certainly a key, right?
Now I'm going to go, and I'll go back to Mr. Liberto because I can. He attempted to occupy. It's an overt act. There's not a crime described, a separate independent. There's no second part of a compound crime there, right? Okay. So you can read that. Does that not put you on notice that that's not a racketeering act?
It does to some extent, Your Honor. I agree with you. But for the state to be able to prove to a jury and for a jury to rely on a racketeering act, we've got to know which ones, right? And it's not enough to say that they've adequately alleged some, but they can still prove others, because that's a problem for the special demurrer. We need to know all the ones that the state would be able to rely on so we could adequately prepare our defense. And so, domestic terrorism, arson, it's alleged in separate counts 2 and 3 for January 21st, 2023. So that's probably the state's strongest argument, that that one's adequately alleged, and that we're on notice that those are acts of racketeering, right? And there are concerns with that domestic terrorism statute that will be addressed in other demurrers. So I want to address those here. And then there's the.
We're not addressing the constitutionality of arson, are we?
No, Judge, but there is a demurrer on us, so
Of course.
both of those could be.
I've read it.
But the indictment makes references to domestic terrorism and arson that didn't occur on the numbered counts on January 21st, 2023, right? But they don't adequately allege the underlying facts as they apply to the elements of arson in those paragraphs. They mention the words domestic terrorism, they mention the words arson, but remember, the law requires them to allege the elements and the facts that apply to those elements.
In the predicate acts, but not the overt acts.
Correct.
Okay.
And they haven't done that. Not only do they not mention the elements in regard to the acts on those dates, for instance, the March 5th music festival and the damage to the construction equipment that's alleged to have occurred on that day. They don't mention the elements of arson or domestic terrorism in those counts, They don't mention the code section. They don't explain how the facts alleged in those counts satisfy those elements, Your Honor. So while Your Honor's right, saying there is some indication that those could be acts of racketeering, I don't know that. It doesn't meet the requirements that the law imposes. We're left to guess. There is a mention of assault in the indictment. It's mentioned a couple times. Nowhere in the indictment does it mention the code section. Nowhere does it set out the elements of the crime. Nowhere does it explain how those elements, how the facts meet those elements of the crime. It completely fails the test of setting forth the elements and the facts required for compound crimes. If they mentioned assault, the indictment mentions assault, but how can that be enough to put us on notice of what is, that it will be an act of racketeering?
And I think that's the Kimbrough case. It's like, okay, this crime could have occurred in 6 different ways. We don't know which one.
I mean, I'm, Your Honor, preparing for this argument. I'm reading through the indictment and I'm just saying, what fanciful argument could be made to this paragraph to claim that it alleges an act of racketeering? Because that's essentially what the state has done up here. We're left to guess because the indictment doesn't tell us, but the indictment has to tell us. We have to know what the racketeering acts so we can prepare our defense. We shouldn't have to guess. In fact, we don't have to guess because the indictment must be perfect and tell us. Then there's influencing a witness. It never mentions the statute by name. It never cites the code section. It never gives a complete recitation of the necessary elements of the crime or an adequate description of how the facts satisfy those elements. All it does is it mentions some of the language from the statute in various overt acts in the indictment.
Don't forget which official proceeding.
Right. It just talks about some of the elements. So it fails the test. It doesn't set forth all the essential elements. It doesn't set forth how the facts apply to those elements. And then there are, for instance, it makes no mention of the element that it must be done to persuade another person by means of corruption or an attempt to do so, or to engage in misleading conduct towards another person. Makes no mention of that element, makes no description of how the facts would satisfy that element. Again, it's a passing reference. We are left to guess. Is this just flourish in the indictment? Or is this an act of racketeering? We don't know. It hasn't been identified. And then, of course, there's the official proceeding problem. The statute defines official proceeding. None of that language is in the indictment, nor is there any description of what this official proceeding that is contemplated to keep the documents from appearing at. How do we prepare for that, Your Honor? We're just left to guess, but we don't have to guess because we're entitled to a perfect indictment. They talk about obstruction. Ask the state to tell you where the elements of obstruction are shown in the indictment. They're not there. And the state rattled off various paragraphs during their argument earlier that they claim allege facts sufficient to show obstruction. Which ones were those? Are they the only ones? Are there others? How do we know if the indictment doesn't tell us? We are going to prepare our defense by the sketchy notes from an argument here by counsel? No, that's not what the law requires. The law requires it to be in the indictment, and they failed to do so. We can't intelligently prepare our defense. There's some talk of money laundering. Nowhere in this indictment as it stands now are the words money laundering used. The elements aren't set forth. How the facts apply to those elements isn't described. There were counts that originally alleged money laundering, but as you know, those have been dismissed, so they're no longer part of the indictment and can't inform this inquiry. I mean, I started writing down a list of potential crimes. It's just a pointless exercise, Your Honor. Because the state is limited only by the list of predicate crimes and their own creativity to argue to you what's in here. But that's not what the law requires. You got to allege the elements of those underlying crimes. You got to allege how the facts apply to those elements. And they repeatedly fail to do that. Now, it's not enough to say, like it might be for a general demurrer, they did it once, right? They did it for the name counts in the indictment. They did it for the corresponding overt acts that can correspond to the name counts in that date. But that's not what we're addressing here with the special. We need to know every racketeering act that the state would be allowed to try to prove from this indictment. And we don't know that. And then turning to any act involving murder, kidnapping, gambling, arson, robbery, theft, receipt of stolen property, bribery, extortion, obstruction of justice, dealing in narcotic or dangerous drugs, or dealing in securities, so long as those things are a felony. There's nowhere in the indictment that says this is an act involving ... We know they haven't identified any racketeering act specifically, and they certainly haven't identified them as being one of these 5B, any other act types. Let's talk about obstruction and murder. What are the elements of obstruction? What are the elements of murder? Where does it show us that in the indictment? It doesn't. What are the facts supporting the existence of those acts as the law requires? We don't know. What are the dates? Who did it? What did they do? We're left to guess. So if we're going to guess, Judge, let's guess. What about the acts described in Part 1 of the indictment? They're explicitly incorporated into Part 2, describing the overt acts, and they say all the overt acts could be acts of racketeering. Could some of those things from Part 1 be the racketeering that the state proves at trial to a jury to support a conviction? It talks about Rayshard Brooks. Well, he was shot while pointing a taser at an officer. Is that not an act involving obstruction? Is that a racketeering act that the state can rely on to prove these defendants guilty of RICO conspiracy? It talks about the murder of George Floyd. Are we to assume that the murder of George Floyd is an act involving murder that qualifies as an act of racketeering, supporting a conviction that we defendants must now be prepared to meet and address at trial? Judge, these examples seem absurd, but they flow directly from the state's theory and argument as to what they have to show in this indictment. Just wrong. The law requires the state to tell us what we're defending against so we can prepare our defense. The state's theory would make it wholly impossible for us to do that. What about acts involving arson? Again, as we talked about, there are some specific numbered counts that address arson on a specific date. The state's arguments, pretty strong, setting aside the other arguments, that they've done what they need to do to identify those acts as acts of racketeering. But as we know, it goes far beyond that. How many of the alleged overt acts involved arson? The indictment doesn't tell us. Which other ones involved arson? How do the facts of those yet unidentified overt acts map onto the elements of arson? We have to guess. It seems that the state's argument is the only limit to the act involving style overt act, predicate act, is they have to allege some facts somewhere that might arguably support it without notifying us, without setting out what the elements are, and without explaining what the elements apply to that. That's simply contravened, as Your Honor has pointed out, by Kimbrough and the other cases addressing compound crimes. They focused on other acts involving arson and obstruction today. What are they going to say at the next hearing for the next motion? What would they allow to be think up next time? How will we know? When will we know? When will the jury know? Will we find out before the jury finds out? It's, I mean, the parade of horribles, Your Honor, is endless. That's why we have the law that requires them to identify everything. And, you know, even if we were to concede the aspect that some of these overt acts adequately set out the facts of some crimes, which we don't, and the indictment doesn't, the indictment still fails the test of a special demurrer in many ways. It fails to identify the facts that support any given racketeering act. It fails to set out the essential evidence, and sometimes it suffers from both problems, as I've previously discussed with some of the other potential hypothetical racketeering acts, yet unidentified in the indictment. The Supreme Court's clear. The state must provide us this information so that we can prepare our defense. And this indictment makes such preparation impossible. And then from there, we can zoom out beyond. My argument to this point has been focused exclusively on those acts of racketeering, those predicate acts. But we can zoom out from there because the state has to prove more. They have to prove all the elements of the RICO conspiracy itself beyond the underlying acts. And I won't bore you with going through all of the elements of that.
Oh, no, please, by all means, bore me.
So the defendants got to endeavor or conspire to violate subsection B as alleged in the indictment. So they have to be, that requires them to be associated with an enterprise. And so they've got, that enterprise must exist. And that enterprise is at a minimum an association or group of individuals associated in fact.
No, you said B. There's many Bs here. We're talking code
Yeah,
section.
yeah,
Are we
16,
talking-
14, 4. And I'm referring to the sort of start of count one of the code sections they refer to in the indictment.
Mhm. Okay.
And they must endeavor or conspire for someone in that enterprise to be engaged in a pattern of racketeering activity. That's all the things we've just been talking about. Either the two racketeering acts or the one act of the domestic terrorism. And the defendant must commit an overt act, right? That's kind of gets us to our universe of elements that they must prove and frames what the indictment's got to put us on notice of. And Your Honor's honed in right away on one of the big ones. What's the nexus between the overt acts and the conspiracy and enterprise? It's hard to answer that question because we don't know what the enterprise is, Judge.
Isn't the enterprise set out in?
Is it the Defend the Atlanta Forests? Is it Network for Strong Communities? Is it one or the other? Is it both? We can't tell.
According to the indictment, defend the Atlanta Forest is a self-identified coalition and enterprise of militant anarchists, eco-activists, and community organizers. But that is the enterprise. It is even, because part one is the enterprise. A, introduction. B, defend the Atlanta Forest. Then we get into the background of the defendant forest in C. D, beginning of the defend the foreign enterprise. That's where we get Mr. Floyd and Mr. Brooks. Though the indictment says defend the Atlanta Forest is the enterprise.
Right, but what is that? That enterprise must engage in a pattern of racketeering activity, right? And so it has to have, that enterprise has to be the vehicle through which the conspiracy is committed that has an object or a goal. And that is what those objects and goals are so broad and ill-defined. It's unintelligible. It's so broad, as Your Honor pointed out, It talks about the black-clad defend the Atlanta Forest participant states that the fate of the Kurdish revolutionaries in Kobani and Seri Nave and all these places, it was partially determined by the bloodbath in Damascus and Aleppo. That's one of the objectives of this enterprise inside the conspiracy. We have to be prepared to defend against that. Does that mark one of the outer limits of it? Is there going to be proof of Aleppo? Is there going to be proof of the unidentified person at trial? We don't know who it is by the indictment. We don't know the relevance. But not only does it state too much, it gives such a broad and vague universe of things that are included within this enterprise and conspiracy that it then fails to give enough detail about the ground it does cover. It would require at least another 100 pages to give us enough information to put us on notice of what these things are that they are even talking about in this section. Aleppo, Damascus, masked individuals that are unnamed. And the jury's going to have the same problem if a case like this is allowed to go to the jury as indicted. How's the jury going to know what the enterprise is, what the conspiracy is, what the objects are? Now, we've talked about ways that you can limit that beyond a demurrer, redacting the indictment, striking surplusage. But we're not, as Mr. Samuel pointed out, we're not talking about removing a word here or there. We're talking about the need for wholesale change to this indictment that fundamentally changes what it is. It's hard for me to even identify what demurrers would remain if we start striking whole swaths of the indictment. Of course, the ones where the state fails to allege the elements of the compound crimes and the facts that apply to it will still be there. But what about the rest? I don't even know. The jury's got to know what's been alleged, right? We need to be able to determine if there's a fatal variance between what's alleged and what's proven. That's why they've got to tell us what these racketeering acts are. Because we have to know, have they alleged it or have they not? We need that to prepare our defense. I go through in my motion at detail, and it seems like Your Honor had a chance to review it, of all the questions, count one, the part one, just defining the enterprise raises, failing to define certain things, failing to identify other things, failing to explain how the enterprise is a subject, define the enterprise.
Well,
How they-
we're talking about Mr. Schwartz's motion here, right?
Which I think was my motion, Your Honor. Sorry, Mr. Schwartz's motion.
He's stealing your thunder? He's co-opting your, on number 3, I've got Mr. Schwartz's signature on the last page.
He's arguing, we filed, I think 3 of the 4 of us.
Pardon?
3 of the 4 of us filed the same.
Okay.
But it
I
was-
just got the one with your signature. I look under your client, I'm going to find the same motion with your signature.
Yeah, I don't think I'm talking out of turn if I say it was just a copy and paste of my motion.
Was it good?
We'll see when I rule, won't we?
And so I hate to go through, this 53-page demurrer, right? I hate to go through every question that this indictment raises. I think Your Honor has reviewed-
46, but okay.
Okay. It has reviewed it and sees all the questions this indictment raises. It doesn't describe the alleged criminal purpose of defending the Atlanta Forest. It doesn't describe how individuals joined the conspiracy. It fails to describe the acts of racketeering activity, and the list goes on and on about all these vague concepts that are introduced but not tied in, not given a nexus to what we're dealing with here. All right, and then turning to part 2, which the overt acts. The indictment sort of breaks these down into various categories. Payments, the indictment. The demurrer breaks these down into payments, online postings, the January 21st protest, the March 23rd event, the flyers in Chupa Soseto's neighborhood, forest occupation, property destruction, and uncategorized.
You're on part two?
Yeah, of the indictment.
Oh, of the indictment. Okay.
Yeah.
I thought part two of your demur.
Well, which is titled, part two.
Online postings.
Yeah. Roman numeral two. Number two within Roman numeral two. So you'd have to back up to get to Roman numeral two. Payments would be 1, online postings is 2, and above that is Roman numeral 2, describing Roman numeral 2 of the indictment, which are the overt acts. Am I making sense yet, Judge?
No.
Okay. The indictment alleges overt acts as we've talked about. And part 2 of the RICO count, pages 49 through 100, alleges 225 overt acts,
Mm-hmm.
right? And so those acts raise all kinds of special demurrer problems. So I just want to turn
225 of them, I imagine.
greater than 225 problems for the 225 alleged acts. And those are the ones that I just described: payments, online postings, and so on. They kind of break out into categories, even though they're not explicitly done that way in the indictment.
I think both sides have categorized them.
Yeah. And so a variety of questions keep rearing their head with these overt acts. What's the nexus between these acts, be them racketeering or overt, and the alleged enterprise and conspiracy? How were the alleged acts connected to the enterprise? How did the alleged acts further the purposes of the conspiracy? How did the defendants not named in the acts conspire or endeavor to further them? For example, when you look at the January 21st protest, the so quote unquote night of rage.
Now, at some point, there's a difference between a proper indictment and adequate proof at trial. We can agree on that, right?
Absolutely.
They don't have to prove their case in the indictment.
Absolutely.
Okay, they allege the nexus, but then they're going to have to prove that nexus, right? But you're just saying the allegation needs a little better, a little more work.
Yeah, I'm not sure they allege the nexus, Your Honor, in
I'm
these.
saying they have to.
They have to, that's right. And that requires answering some of these questions that we raise. Maybe not every question, Your Honor, right? It's kind of one of those things.
There's a lot of questions.
There's a lot of questions, but you may not have to get all of them, but you got to get some of them to put us on notice. I raise every question that can be asked. Not every question has to be answered, but somewhere, some fundamental aspect, some of those questions have to be answered to put us on notice. And I agree, they could answer some, but not all of them, and they'd meet their obligation, but they haven't answered any of them, Judge. This January 21st, night of rage, how did an individual on a different date that wasn't there conspire, endeavor to have that happen? Well, we don't know. We just have to guess. And so turning to the overt acts alleged, the category of payments, there's all kinds of these alleged payments that mostly allege Savannah Patterson, Marlon Katz, and Adele McLean reimbursed others for various items with the funds from the Network for Strong Communities.
And given that the money laundering charges have gone by the wayside.
Is this a racketeering act? We don't know, Judge. We don't have to guess because the indictment has to tell us, and this indictment doesn't. And it talks about all kinds of items that were paid for. Forest monitoring equipment, you saw it in the demurrer. Forest monitoring tools, food, gloves, tarps, power packs, deep May tuition, glue, bins, generator, restroom support, tools. I mean, the list goes on and on and on and on and on. How Did any of those things further the conspiracy? What's the nexus between a tool and the conspiracy, between a power bank and the conspiracy? I don't know. It fails to describe how each item was used to further the conspiracy. It fails to describe how the transfer of funds was made. It fails to describe how or if the act was connected to the enterprise, how they furthered the RICO conspiracy. Like I said, maybe you don't have to answer every question, but you got to answer some. We've got to know what we're facing. And of course, as previously been identified, and who are the unidentified co-conspirators whose identities are unknown to the grand jury? Not only do we not know if it was the three named defendants, it could have been any number of people that we don't know that did these. How do we defend it against that, Judge? We can't. Then we turn to the online postings. They generally allege that Couts, Patterson, and McLean, and then again, other unindicted co-conspirators posted to scenes.noblogs.org to threaten others. We don't know how they posted the post. We don't know the content of the post. We don't know how it furthered the conspiracy. We don't know who's the target of the threats. We don't know how these posts demonstrate that they intended to cause and induce the alleged target of the threat to withhold records, documents, and testimony in official proceedings. Is this a witness influencing act, predicate act, active racketeering? I mean, it mentions some of the language from the statute, but it doesn't meet the requirements of setting out all the elements and how the facts apply to them. What are the documents that they're trying to get them to withhold? What's the official proceeding? How's it connected to the enterprise? How did it further the RICO conspiracy? I mean, these questions repeat over and over and over again in this indictment. This indictment raises many more questions than information it provides to us on how to prepare our defense. And then we turn to the quote unquote night of rage on January 21st, 2023. What's the night of rage, Judge? Do you know what it is after reading the indictment? I don't. How did these actors join the night of rage? It doesn't, what was the arson that was committed? How was it committed? Again, what were the elements? How did the facts apply to the elements of arson? Is this an act of racketeering? Or is it not? Is it just an overt act?
Does it not appear from the indictment that someone took a hammer to try and break into a building and set it on fire? Now, where the Night of Rage moniker came from, that's a whole nother issue.
I would submit that it doesn't, Your Honor. Let's go to Act 152.
I'm getting there. Yes, 152.
And are you referring to 156? Did possess a hammer while attempting to break into 191 Peachtree Street?
Well, 155, possess an accelerant while attempting to break into 191. Did possess a hammer while trying to break into? Now, I don't know how spray paint has anything to do with arson, but that's 157.
How's that connected to the night of rage? We don't know. What the night of rage is, we don't know. We don't know what the property damage might be. Maybe it's breaking a window. They say they had a hammer. And then,
As I said, there's perfect, and then there's perfect.
and how is this domestic terrorism, Judge? How does this describe?
That's a different motion.
Well, I mean, it says it right there
Well, I know there's.
in 155. commit the offense of domestic terrorism. How do these facts establish the elements of domestic terrorism? We don't, they don't, Your Honor. The allegations of these facts is wholly insufficient. Had a gas can, had a hammer, some spray paint, attempted to break in. And that's supposed to satisfy the elements of domestic terrorism? I don't think so. The indictment doesn't meet the requirements of adequately alleging these predicate underlying crimes that's required when they allege a compound crime like RICO.
Um, Interesting. It says domestic terrorism. It would lean more toward arson, but okay.
Is that a racketeering act that we have to be prepared to meet, Judge? Might be, but that's not enough for me to say it might be, for you to say it might be, for them to argue, oh, it is. The indictment has to tell us. They don't get to tell us. The indictment has to tell us. And these questions repeat over and over and over again. Like I said, it doesn't have to have every fact we want to know, but it's got to give us enough to know how's this domestic terrorism, right? And let's turn to the March 5th event. This is the music festival and the damage to the construction equipment. Many questions arise here. Where did the criminal trespass occur? How were the elements of criminal trespass committed? How did the criminal trespass further the occupation of the DeKalb forest? How was it connected to the enterprise? Remember, we don't have to answer everyone. We got to answer some of these. I mean, we don't even know where the trespass was supposed to have occurred. Was it where the music festival was? Was it where the construction equipment was? Was it both? These are areas where the ownership and ability to exclude people from the land is not clear based on the indictment. And we know that there are areas that the city had under control and areas that the city didn't have under the control. Which one was it? How do we know? We can't. How was the mob organized? How did the mob cause property damage? Where did the mob attempt to cause property damage? These are things that are not in the indictment that we don't know. And I mean, they're set out in detail in the demurrer, Judge, all the different questions that could be asked. But it also talks about domestic terrorism, talks about arson. We need to know the elements. We need to know how the facts apply to those, and the indictment doesn't do that for us. How it was connected to the enterprise and how it furthered it. Then we've got the flyers in Trooper Sosato's neighborhood. How are those connected to the enterprise? How did they further the conspiracy? There's the forest occupation. Where did it occur? How is it connected to the enterprise? How is it connected to the conspiracy?
Are you looking for GPS coordinates, sir?
Well, I mean, when it comes to the trespass, when it comes to the forest occupation, we need some definition, some description of where they were allowed to be and where they weren't. And this indictment doesn't point us to that. And the questions are the same in the group of the property destruction group of acts. For instance, how does the indictment tell us that by vandalizing a Brassfield and Gorey office building in Cobb County, they demonstrated that they had the intent to cause and induce Brassfield Gorey officials to withhold record documents and testimony in official proceeding? What's the nexus between those two things? What's the connection? We're left to guess. What's the official proceeding? And how did those acts connect to an effort to get them to withhold documents? For each group of acts, the same questions can be asked over and over again because they remain unanswered. In the end, Judge, we're left with an indictment that doesn't tell us what we need to meet. We're left to guess, and that's a result prohibited by Georgia law, and that calls for a granting of the special demurrer.
Okay. Before you jump up, I'm going to take 7 to 10 minutes, and then we'll be back. And who's going for the state?
On this one, Ms. Dixon is going to continue on this one.
Okay. Take 10, y'all.
Reply to Judge Emerson's email thing. Let me know if you guys object to the continuance and do it quickly. So,
No, we do not object.
yes, we do.
No, we.
I know, that's what-
No. Do not tell him we object. Tell him no, you do not. It says we cannot join in the motion. You just need to say, we don't have a position. Because it says their motion alone. It doesn't say not agreed to by the state.
That's what it says. It says, on a continuance granted upon a motion made only by the
The defendant. So we just say to him, while we don't really take a position, we don't object. This is his motion and we are not joining in this motion. And I think that does it. But don't tell him we object because he will set us. I am not interested in that block.
but not at the moment.
All right, I'm gonna go out here. I gotta go. Ladies.
Yeah, go do that. Go.
Really bad. I'm sure there's gonna be a line, so somebody's looking at me, taking this with me.
That's fine. I'll be here.
Jack, can you speak? Okay, I'll be sure to move my bar because you're speaking. I can hear you.
There you go, Mike. I got the judge on another case. You need to respond really fast. I don't know if you're fine with leaving her. Roy Mark and Craig Hill. Very good trial. Roy Barnes is former governor of the state. Forced that already. Yeah, well, but he was young when he got, it's not like he's over the hill. But anyway, she got this. First thing you go is governor's office. Administrative process or commission investigations. He gets suspended. And then it waves, right, then it waves it into indefinite, instant use. It's just like trouble. Almost like. Roughly, just one. All of yeah, they can do my. No, doing something. I mean, like.
Talk much longer.
Okay, you know, it's making. $130,000. Oh. We didn't. Records. Let's go the whole house. So charge. Always cover it. Always cover it. Check too. It's all of them. Yeah, right.
Can I say that there's a way of saying this, I'm trying to come along, but I'm gonna say it very quickly. We can't help with the fact that they did so many actions that were involving setting fire to things and committing arson. Like, they're only limited by their imagination. They're limited by the statutes, which narrow what we can do. And what we allege in an indictment. Yes, there's a lot of them alleged in this indictment under our theory of the case, or our sections of the court. But that's because there's a whole lot of them that are, in fact, within the meaning of predicate acts, or that are alleged in that word. Does that make sense?
I think so. Starting.
No, I'm having a struggle. I talked up there 2.5 hours.
Like you can go over the couch, not in a bad way, like you knew to do it, but we knew ahead of time.
Did you could see me do that?
No. Well, I slowly moved your water over there, but we knew that was gonna be the way up front, remember? Because remember, like, just by the way they listed them here, you were so front loaded on this, having so many of these in the
I
front.
know.
And I am backloaded,
I
having
know.
all these on the
I know.
back. I mean, they didn't
Oh, I
make that.
know, I know.
What's funny is, when the initial list came out, pretty well
No
broken
idea.
up.
Right.
Pretty well broken up. They did a good job. And then when the second list came out with the list, we were like, oh.
Appreciate that question. Good to know, 5 o'clock at least the cutoff from.
What's, everybody else needs to
You're
know.
Liberto, right?
Yep.
Okay.
Just for.
You've been the primary conversation all day.
You pick up or you know,
Yeah.
all that sort of stuff.
Oh, absolutely. Yeah.
God, he's not going to keep delaying that unless there's a spectacular reason.
Oh, absolutely. Yeah. It's at least you good to know in the back of your head. It's not going to be 8 o'clock.
You're like, all right, let's do this. You're like, all right, they'll realize.
I was saying I'd sell a kidney for a cup of coffee right now. So I was just thinking, I'm like, oh, man, that's
Pretty quick, yeah. So.
Yeah, I don't think you would. It's just, I didn't bring it. Yeah, no, I figured you'd be fine if you could produce it.
Got it.
I could just see his all.
There we go. Pickup machine. I got an espresso machine. We'll be making. You want milk with it? Or what are you thinking?
What are you doing? I'm working the espresso machine.
It's 2.5 pounds of pressure you need for the perfect cup here.
The table, yes. But that's what this space does. It's for.
I might be giving it out to the jury just to make sure I get them on my side. Except when it's your argument, it's gonna be boring. I'll just give them fake decaf so that they fall asleep.
There's gotta be some sort of like placebo effect there.
Oh, sure.
It's real.
Sure.
And
Something happened to me recently, and I just knew it was placebo effect. It's like something. It was medicine. It was a headache. I was dying. And I took some, and it's like immediately I felt better. I'm like, there's no way that works.
no.
Instant.
It takes like an hour for that.
Yeah.
Hey, when did they change the RICO statute to remove or was Georgia, quite frankly, was the state statute ever limited to the criminal gain? At least the federal statute used to limit they had to, anyway, we had to prove, I don't know if it was limited in the purpose, but the purpose had to relate to advancing their own
If you'd asked me
pecuniary
at
gain.
9:30 this morning, I could have answered your question.
Okay,
Right
anyway,
now.
do you know?
Purposes of a gang?
No.
Actually, when they removed the financial?
RICO, yeah, they used to have to
1996.
establish. See,
Or it might have been 97, but it's somewhere.
anyway, in the late 90s, they
Huge
removed that.
overhaul in 96. Because there was that 96.
Was it a
overhaul.
legislative intent?
It would have been that is what I'm
There was a
referencing. Yeah, I think it was 96.
overhaul,
I
just
have
like-
them. I have
It was a
some
federal
various
overhaul.
House bills, but I can't remember. So,
There's an overhaul in 96
Yeah.
that I think
and
is
that
what
was the
you're talking about.
legislative.
They changed the elements. They made it easier for you. You guys changed it. You wrote a bill,
It
sent
was
it up.
broadened.
And
Yeah,
you
yeah,
guys, it's in the
yeah.
AG's
Yeah.
office, wrote a bill, went up. It
Yeah,
got
yeah,
it
yeah.
changed some elements of what needed to be approved.
Yeah, and I think pecuniary gain got taken out of that. I can't remember.
Well, this was really, I think, related to some civil issues. Some civil issues made it so, because people were suing under RICO and they started having to prove financial pecuniary gain. So the AG's office said, hey, we don't want to have to prove this element. And it was related, I mean, the cases that it was from were civil cases where because you get treble damages if you can find it under RICO. So of course the law changes because the money's there and all the rich guys. Triple my money.
Trial Lawyers Association is powerful in those days.
Yeah.
You know, it's funny, I was.
Then they found that driving.
Working on some engineering.
Drone weed.
Oh, yeah. You know. I don't know if they were talking about criminal case in general, or they were talking about fatal sentences. They were like, yeah, oh, I'm so sorry. Yeah. Literally wrong. Go to. They were saying.
So just, I mean, we were in Gwinnett. I do a lot of Gwinnett and they killed somebody, but that was him. The guy pulled out a cord and shot the guy. I was in court at reporter's court where it's just right next to the building, and it was all on fire and stuff. And we go in and like tell us I killed the attorney.
That doesn't happen more badly.
We were just out there at the lunch break, sitting in front of that 284A, and two attorneys screaming at each other about giving us family stuff about visitation and all this. Like, he's now freaked out, you know. It's not your visitation.
Just. It is. You're talking about money. You know,
Absolutely. Yeah, well, it's very emotional.
anymore. There's some sort of some.
Yeah, you want to
Who's arguing that?
I've fallen in by accident to this family life. Mostly sent around TPOs. I've done it twice. And the first time I said absolutely never again. And I remember sitting there the second time, I said, what did I tell myself?
The connection is pretty crappy, it looks like.
Exactly, that was it. Well, this was not, it was infidelity. It was fighting, somebody cheated on somebody.
And then there's fighting.
My client insisted that we enter this picture. Yeah. Evidence. He's like, no, put it in. It looked like he had been hit in the face. And like I was trying to like in the middle of the hearing say like we wouldn't he like insisted. So I said, sure, put it in. He's really strong about it. During the hearing, she comes back because it showed that she punched him in the face. Then we get the full picture with the text message chain of him saying, yeah, no, it was like a friendly text message he sent to his wife. I'm like, well, you made your own back here, buddy.
What's the?
Okay.
Years back.
John,
Yeah.
I'm sorry to interrupt you. Do you have his motion anywhere? I need to figure out whether he argues in his written motion continuity, because if so, he does.
And now they're helping to get out of here by Thursday.
All right, so my next question is this. If I don't address it, because I think one of them is gonna argue it, but they don't argue it.
Right.
Go ahead. Yeah, go ahead.
For
That he argues it doesn't allege.
well, we'll be in the city, but the wedding is right out. Are you coming?
Yeah.
Good, now, good, you have family in Schenectady.
It's the weather.
They say stay seated.
But I just
Yeah,
wanted
oh, yeah, it's my- for my family show.
Okay. State?
One clarification as Ms. Dixon comes up, you asked Mr. Garland if it's a fair deduction that an overt act that clearly doesn't allege a criminal offense couldn't be a predicate to RICO. And that's not what the state said at some point today. But then, just based on that comment, I want to make sure we're on the same page. The state has conceded that a predicate act must be a criminal act?
No.
No, okay. Good. Thank you.
Okay.
That would overstep there. Judge, first off, let me apologize if I just overspoke.
No, I'm curious to hear this now.
Okay.
So a predicate act doesn't have to be a criminal act.
No, not one of the racketeering activities. And let me get my case, Judge.
And you're basing that on 5B.
Yes, and the case, well, particularly on Dorsey, this Georgia Supreme Court case that specifically held that. And I know I get to reading too fast at times. I'll try to make sure and let me just read a little bit more and not try to go so fast. Okay. Dorsey challenges, excuse me. This is the Dorsey v. State case.
Right. No, I remember, yeah.
Okay,
That
all right,
That Mr. Samuels vehemently disagrees with, but is still good law.
Still good law. And just so that we understand just why Mr. Samuel's so vehemently, and I understand.
Because it's not good for his client.
Well, and I mean, I understand. Definitely. But Judge, just to give it some perspective on why my answer to that is no. Dorsey challenged category 5, which I talked to you before, predicate offenses. Each concerning an act involving murder. The basis for his challenge is that a preparatory act which standing alone may not be criminal cannot constitute a RICO predicate. And then it goes on to say it belies that claim. And then it goes on to explain that under subsection B, 5B, so it's you know which one I'm talking about. It does not have to be a criminal offense.
Gotcha.
Okay, all right. So that's the answer to that. As far as the argument raised by Mr. Garland, I'm going to.
But if it is a criminal act,
Yes.
then you have to delineate and put forth all of the elements of that?
If it is a criminal act, you have to put forth all of the elements, all of the essential allegations and elements of the offense within the indictment. Yes, sir. Not within that one
Even
count.
if it's not if it's one of the 225 overt acts?
It does not have, okay. So for a predicate act, yes, somewhere in that indictment.
If the predicate act
Yes.
is also a criminal act,
Yes,
then if it is enumerated within the RICO count, it needs the elements of the offense.
the state's contention is that as long as the indictment read in the whole sets out all of the elements of that underlying offense.
That's exactly what Kimbrough said you can't do.
That Kimbrough was not a compound felony case, I don't believe, Judge. I don't believe, because that Sanders,
It was a RICO case that dealt with
Was a B.
drugs.
but it was not a conspiracy to commit RICO. And technically, a conspiracy to commit RICO is like a doubly compounded case. And I mean, to be quite frank, I haven't read the Kimbrough case since September of last year in great detail. But I have read the Sanders case, which is in 2022, and it specifically states that in compound cases or twice compounded cases like conspiracy to commit RICO.
Well, I think Kimbrough's even worse for you because it's not compound. Compound, you got to do it, but Kimbrough says you got to do it in a non-compound case because in Kimbrough, because I read the Court of Appeals one first, read what they did wrong, and then go see what the Court of Appeals tells them they did wrong. And in the case at the Court of Appeals level, they said, hey, see as follows below. not unlike your page, part 2 on page 49. The defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described. See below.
Yes, sir.
Okay. Now, this is all in one count. The problem with Kimbrough was there was count 1 and then they enumerated the other counts. You just enumerate them as separate overt acts.
Yes.
But they still wanted, you couldn't read it, specifically they said it's not a read as whole kind of a thing.
I don't know, Judge, quite frankly. I mean, I would have to really compare and we can do that. But what I know is,
We have held that an indictment not only must state the essential elements of the offense charged,
yes,
but it also must allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet.
yes.
Okay, and that's the English case also as well. And they also kind of get a little upset that the indictment says nothing more, however, about the nature of the alleged connection between the enterprise and the pattern of racketeering. Which these folks are asking for greater detail about the connection by their special demurrers. And this is Kimbrough on page 880. Go ahead.
So Judge, I don't know where we're.
Where we are was, not every predicate act has to be a criminal act.
Yes.
And Dorsey.
Yes.
But if it is a criminal act,
if it is alleged under A, yes, sir. Or domestic terrorism, yes,
if it's a criminal act.
yes.
Because it can also be a criminal act, it can be a criminal act under B. If it's a criminal act, you have to set forth the elements.
Within the indictment, yes, sir. Or facts, what does this, let me quote it. The state's position is
And
that,
you're at Sanders,
yes, sir,
all right?
on page 200. And
In order to satisfy due process, when an indictment charges a compound felony, such as felony murder, but here it's conspiracy to commit RICO.
Rico.
The count charging the compound offense, which here's count 1,
Yes, sir.
and the listing of overt acts, I inserted that, but the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely. That didn't happen here. It did as far as the arson and the domestic terrorism.
Yes, sir.
But the rest of the stuff, not so much.
Right.
Or the indictment must elsewhere allege facts showing how the compound offense was committed. Okay?
Yes.
So Mr. Garland was up here saying, show me my essential elements. When you say where there's one count where it's just, this is domestic terrorism, I'm gonna hope that you will admit that that's a predicate act.
Yes.
Okay, so he wants to know where are the essential elements of that, and that's count.
Which paragraph, Judge?
Yes. No, you're fine.
Second.
152.
Oh, I know that one, Judge.
Join the night of rage in Atlanta and cause arson and property damage and thereby committed the offense of domestic terrorism.
Yes. So my answer to the question of where are my essential elements is count 2 of the indictment, which is allowed under Sanders with that, you said or. So it's either in count 1 or alleges another count in the indictment, count 2, or sufficient facts to show how the compound offense was created. We're under 2 for that.
So you're relying on count 2 for that.
Yes. To establish the, yes, sir, for the domestic terrorism.
Oh, and then we're gonna get to the demur on that count later.
Yes, sir.
Okay. Okay,
Okay,
but that was just one example of the domestic terrorism. There are other predicate acts in here, criminal acts.
yes,
You alleged an aggravated assault
yes.
by giving someone information.
We argue that, yes, sir.
Yeah, okay. Essential elements.
And the elements of aggravated assault are the fact that an assault was committed and it was done with a deadly weapon. And of course, under Georgia law, you don't have to plead or allege the party to a crime, whether it's aiding and abetting or party to it, we don't have to allege that. And so whether or not there are facts sufficient in the indictment to establish that, aggravated assault could be, first of all, you would have to say, could aggravated assault be holding a gun to somebody's head and specifically naming that person, saying it was an aggravated assault? State says
Slow down,
yes.
slow down.
I'm sorry. I do that when I get, sorry. And if then providing information to that person, again, that is our argument, that is, anyway, that's our argument as to that one incident. But with regards to the other parts, it is that you have acts involving, and really, Judge, and I mean, you had, excuse me, I made an extensive argument before the court, which went through why or how we believe there's certain predicate of acts, racketeering activities, and predicate acts that are criminal offenses under A have been alleged. But their entire argument, really, with regard to the predicate acts being alleged with sufficient particularity, or it really ignores B and the Dorsey case.
Well, I think their initial argument was, tell us which ones are predicate just to start with.
Okay, let me get to
How
that.
about just that? Because you say there are predicate acts or acts of racketeering activity, which would be the predicate acts, as described below. But it is not your contention that all 225 of
No.
these are predicate acts,
No, sir, it is not.
and none of them are individually identified as predicate act. So how is that not leaving it up to the defense to figure out which predicate acts they need to defend against? Because let's say there's only 5 of them and they can knock out 3, they win, right? Because you gotta have 2, you gotta have 2 predicate acts. If you only gotta get 3 to win, okay? Mr. Samuels?
I did mention that I'm not good at math. Could y'all quit?
I am mathematically correct, am I not, Mr. Samuels?
You win if we knock out 4.
You win if you knock out 3.
There's still 2 left on yours.
No. If there's only 4 and you knock out 3, there's only 1 left. Okay.
I'm lost. He said 5.
What time is it?
So
Yes, sir.
if they don't know how many predicate acts they have to defend against, how is that not leaving them to guess? Because they're going to marshal their energies, because if somebody bought food and that's an overt act, they might not give a fat baby's behind about fighting that one. They may say, yeah, my guy bought food.
Yeah.
Okay, so how are they not left to guess which ones are and which ones aren't? Because some of them are crimes, and you're saying, well, it's pretty obvious that this is a crime. But on the other hand, you're now telling the court, well, predicate acts don't even have to be crimes.
That's true.
Under Dorsey, agreed.
Yes, sir.
How are they supposed to know which is which?
Based on the contents of the indictment and the allegations and the statute and how it's defined. And in fact,
And I think if you would have said, hey, this is a predicate act under 5B, this is under 5A, Roman numeral, whatever. If you had identified that, instead of leaving it up to them to guess, they would know how many out of 225 are the predicate acts that they've got to marshal their resources for.
I do not disagree that if we had delineated, that it would make it easier and better for the defense.
How
and more
about we
digestible.
call it perfect?
Well, perfect in the sense that is not actually required as the state's position. Because they offer no authority whatsoever for the position that the state must delineate or with nomenclature. So and I did look, maybe there's a case out there. If so, I'd like to see it. I have not been able to find it. But there is no authority that the state is aware of or that I have seen cited by the defense that says that to be a sufficient allegation in the indictment, that a RICO charge must delineate these are predicate acts. And Judge, in that context, there is a case, Brown v. Friedman, 222 Georgia Appeal, Georgia App 213 on page.
Wait, hold on.
I'm sorry.
How about just the fact that an indictment has to enable the defendants to prepare for trial? And if they don't know what predicate acts that make up one of the three counts, if they don't know which acts are going to get their clients in trouble for that one count, how are they able to prepare? They've got to guess how many out of 225. Because like I said, if there's 5, then they got to knock out 4. If there's 200, then they got to knock out 199. But they're left to guess.
And Judge, I would go back and I'd come back to Brown, but give me 2 seconds to find the cases that I have cited here.
Especially where a predicate act doesn't have to be a criminal act. That makes it even harder to show with just there are no elements to put in there. What's the element of a criminal act? Well, it's not a criminal act. It's a predicate act.
Judge, and I do not have this, the entirety of this case in front of me. However, I think this case was cited by the defense, 303 Georgia App 183 at 186.
Hold on a second.
Yes. John.
303 Georgia App.
Yeah. Yes, sir. 183 at 186.
183.
And in candor, I do not have the entire case before me, but I have a quote from the
State v. Bear,
Yes.
2010.
on page 186.
Hallie, can you give me that side again? Here you go.
5. 7.
Thank you. I'm trading.
Well,
That's right.
you don't like the first sentence of
No, sir.
186,
I do not.
which is the state's argument ignores important facts.
Yes. That's never pleasant for a prosecutor to hear.
Right. The test for determining sufficiency of the indictment, is that the language you want me to read?
Yes, sir.
The test for determining the sufficiency of an indictment or accusation is not whether the charging instrument could have been made more definite or certain. Agreed. There's perfect and then there's perfect. Or for that matter, perfect, but whether it contains the elements of the offense intended to be charged and sufficiently appraises the defendant of what she must be prepared to meet. And in case any other proceedings are taken against double jeopardy. So this is the same language we've seen. Yes, this is.
Yes, sir, Judge. I'm trying to find the portion of.
Okay, and then it says, thus, if the accused can admit to all of the indictment or accusation or citation charge and still be innocent, the indictment or accusation is defective. That's as to a general demurrer.
Yes.
The argument Mr. Samuel's partner was making was special demurrers, saying, hey, where is it? Because general and special demurrers to count 1, insufficiency. I don't know which of these, he's saying, he's admitting some of these have criminal elements to them, but they don't satisfy the requirements because they don't have the actual elements in them.
Yes, sir. And
And I don't know whether it's a predicate act or not. It's a criminal act. I don't want my guy pleading to that. But is it predicate or is it just a benign overt?
so, Judge, and I'm struggling, but to locate where in that particular case it says this, but I will assert to the court that there is established Georgia case law that says in assessing the sufficiency of the indictment, that you read the indictment and the allegations contained in the indictment along with the criminal statutes. And so, for example, and this goes
Although
into,
recitation of the statute may in certain cases be sufficient, though not may be a sufficient, though not desirable method of apprising a defendant of the charges arising against him. Recitation of portions of the statute is not sufficient if, reading the accusation together with the statute, a defendant is unable to determine which of his acts are alleged to be criminal in nature.
so that is one of the cases. So that
Insert the word predicate act for criminal in nature. Because you know, there's a requirement of so many predicate acts, right? 2 predicate acts or 1 domestic terrorism, right?
yes, sir.
Okay. So if a defendant is unable to determine which of his acts are predicate acts, are alleged to be predicate acts,
Yes, sir.
is that not problematic?
I think it is not I'm just going to say it. I think it is not the best way. I think that it would be more clear, but I do not think that it is fatal to not identify them. And let me give you Brown, and I do have a copy of that whole case, Judge. Brown v. Friedman, it's a civil case, and so I understand that it's a RICO case and therefore has,
You know,
sorry,
not for nothing.
yes, sir.
You know how I read all their motions? I would have loved to have read some responses. And as Mr. Samuel pointed out, I had nothing to read from the state on this, nothing. And it's been 2 years.
Yes, sir.
Because I kind of pride myself on trying to come prepared.
Yes, sir.
So what's your Brown site?
The Brown site, Judge, is 222 Georgia app 213. And I'm gonna,
Hold on.
okay.
There she blows. All of these cases cited by both sides all have big yellow squares, big yellow triangles next to them.
I will tell you that there was not a single one that I'm citing that you don't look, because it's all distinguishing. And so it's,
And it's on other grounds. It's,
yes,
yeah.
it's,
Well, again, all right, I'm on it.
so Judge 217, and essentially the reason I am directing the court to this is this was not particularly the primary issue in the case. However, in that case,
Summary judgment case.
it is a
Okay.
summary judgment case. And Brown contends that the trial court erred in granting the summary judgment to the defendant Friedman on the RICO claim, a RICO violation with the code section, and any subsequent recovery through another code section requires that Brown show an injury, a pattern of racketeering activity. A pattern requires at least 2 interrelated predicate offenses. Here's the important part. In her complaint, Brown does not expressly allege which of the acts she recites in her narrative of events constitute predicate criminal acts for RICO purposes. In her brief to this court and in her response to Friedman's motion below, she alleges theft by conversion, theft by deception, and mail fraud, which constitute RICO predicate acts. Although she does not specify all the acts which she alleges constitute these crimes, at this point, she is not required to do so. Friedman can ask for a more definite statement. So
Friedman's not going to prison if he loses.
I said that it was a civil case right off the
Yeah,
bat.
that's,
And so, but my point is, Judge, that that the only case law,
let me rephrase that. Friedman didn't face prison if he lost.
that's correct. That's correct.
Last time I checked, there is no mandatory sentence on a RICO case.
Correct. Correct. And it's not a mandatory on
It's
DT.
5, but it can be probated.
I was about to say. So,
The agreement of the state. What, on domestic terrorism?
yes,
No,
sir.
on racketeering it's 5 to 20, but the 5 can be probated.
Right,
That's
right.
I was wondering about that.
It's not mandatory prison time, but mandatory splitting hairs. It's not relevant.
There's no mandatory incarceration for, potential mandatory incarceration for Mr. Friedman.
That's true, Judge. I'm not
Okay, so
disputing
this-
that. It started at the very beginning, said this is a civil case. However, there is no, again,
And at this point, she is not required to do so.
they're talking about,
Friedman may move for a more definite statement.
Yes,
We don't have that in the civil arena. What we have is a general and a special demurrer, and they are doing that. But you're not allowed to amend your complaint. You can't amend your indictment. Which is, so I think that's just easily distinguished away. So I'm gonna close that window.
yes, sir, close that window. It was, and it goes back to, I looked hard, there is no case law that requires that they be delineated. I understand what your point is.
There is
to the
case
state.
law that says they gotta know what they're defending against.
Yes, and-
Lots of it.
And the state's position is that when you read the statute, which is a limited number of excuse me, when these lawyers or their clients read the statutes, which defines specifically what racketeering activity is, and it defines which racketeering activity, excuse me, which criminal offenses can be racketeering offenses, and then it defines in subsection B a much narrower limitation of which criminal offenses, acts, or threats involving those criminal offenses can be the basis of racketeering activity. And that from that, when the state alleges that he participated in, and I don't have one in front of me because I just turned the page, but when there's an allegation in a paragraph in those 225 overt acts, and it says he did X, Y, and Z, facilitating an arson, and the word arson is used, I think any rational person and reasonable person would know that that is an activity or an action or an allegation of an act or threat involving arson. So yes, I think
So then it's a criminal act, right?
it would be under B. So no, sir, we don't have to allege that, we don't have to allege an arson. We have to allege under B, we have to allege that they committed an act or a threat involving arson. And so when we say, let me find one, Judge, if you don't mind. Will you find
Please.
one of the paragraphs that mention arson, but don't charge arson for me, please? Mr. Fowler's going to get me an example. Actually, 194, hang on, I may have one. Okay. This is an example, Judge. 24 times on 194 through 217 alleges that on or about March 5th, 2023, insert name, 24 of the different defendants, did join an organized mob and succeed in overwhelming the police force, thereby aiding and abetting in the offense of arson. And then it's with the purpose. So, I mean, with the attempt to occupy and prevent. Any person can read that and say,
Is this the arson that occurred back on January 21st?
no, it's on March 5th that he did join the organized mob to attempt. So reading it says, look, these folks got together, they organized a mob, they succeeded in overwhelming police and aided and abetted in an arson. And that was on March 5th.
Because the arson that's alleged in the indictment is from January 21st.
January 21st. And that is alleged in a different, there are facts, the facts supporting the overt acts and the racketeering activity is alleged for that particular arson
In abetting the offense of arson. How are they supposed to know which act of arson they're defending against?
So I don't, first of all, I don't think that's where we get into, I don't think you have to allege that. It's just like that Dorsey case. Well, while I understand people may want us to have to, we don't.
Is aiding and abetting arson not a crime?
Aiding and abetting arson is a crime, but they are not charged with aiding and abetting an arson.
Okay,
And
but it's
they're
a
not,
predicate act that is a crime.
we are not,
Yes?
I mean, it could technically fall under A, but that's not how we're charging it. And
We
it-
don't know because you didn't say.
I think it alleges the facts necessary to put them on notice that those are actions involving arson. And there are others,
What arson is going to be what they're going to ask? Which arson did they aid and abet?
the one on,
Because the only one that's listed is the one on the 21st.
that's the only separate offense of arson. But
Okay.
it is not the only arson that's mentioned because it specifically says on March 5th, they aided and abetted an arson. They're not
Okay.
separately charged with that, but
Can you show me an overt act in the list of 225 that just talks about arson? Because I'm looking, like I said,
maybe.
205 from 194 on.
I don't know if it uses the word arson, Judge. 2 seconds. Is arson used elsewhere in the overt acts? Will you check for me?
Well, again, how are they not guessing then?
Just,
I mean, I'm not trying to be flip. I'm genuinely curious.
so Judge, to the ones I'm talking about, the 24 that I'm speaking of,
Starting at 194.
starting at 194.
Okay.
I will mention, if we look at Dorsey, I understand the court's questioning and point with regard to that, but Dorsey did reject this idea. So in Dorsey, the defendant was charged with acts involving murder. Murder is also an A offense, under where you're actually charging a predicate act that is a criminal offense. Under A, you must set out all of the elements because you're saying they committed the crime.
Hold on a second. You're looking at page 541 of Dorsey.
Yes, sir.
Dorsey challenges category 5 predicate offenses, each concerning act involving murder.
Can you find the arson mentioned anywhere else?
I'm looking.
Oh, there's one. There's one.
Not pretty. Yep, yep.
Okay, here's the difference. Though. I don't think I heard them say, Mr. Garland, you correct me if I'm wrong. They're not arguing that that act can't be a predicate act. They're just saying it's,
Two different things. I understand, yes.
he's
it's two different
not
things.
challenging that that can't be a predicate act.
Not at this point, no, sir.
Mr. Garland, is that correct?
We need to know.
He's just saying we need to know.
And if it is, the indictment's got to tell us, not the state. The indictment's got to satisfy the requirements of the elements and the facts that apply to it.
Well, and what she's saying is,
That's what he's-
just like this said, an act involving murder, the state has said an act involving arson and terrorism and domestic terrorism.
Yes.
And, Your Honor, I could wait till the state's done.
Yeah, you're gonna-
Response to.
All right, well, go ahead. Go ahead.
So, Judge, the other thing you had asked me for other references to arson, another reference to arson is where one of the, and let me not be vague,
Please don't. Well,
you may want.
because I think that's what most of these folks here are accusing you of right now.
So the word arson is also mentioned in paragraph 130, which is one of the publishing a post on scenesnoblogs.org, claiming
130.
for responsibility for an arson and using that as a way of threatening.
So whoa. Them being in the forest and joining a mob in March is aiding and abetting
No.
an arson that occurred in Portland on January 1st?
No, sir. I am confused as to what your question was. I thought you were asking me to tell you where else in the 225.
How are they
overt
supposed
acts.
to know which arson you're talking about? Because the murders in Dorsey, there was but one murder. There was but one murder. So an act, a predicate act involving murder. Everybody knew which murder they were talking about. We don't know, they don't know what arson you're talking about.
The allegation is that they attempted the arson on March 5th. So and did acts to attempt that
Dorsey was
action.
charged with a murder.
Yes, sir.
One body,
Yes.
okay? Some of these defendants are charged with one arson that occurred on January 21st?
Yes.
Okay, and in March, they're accused of aiding and abetting arson.
Well, there's also accounts in the 225 that pertain to,
Those aren't counts.
sorry, there are also paragraphs in the 225 listing of overt acts, which include predicate acts.
Is there even an arson that is alleged on March 5th?
There's not a separate crime of arson on March 5th.
But yet
because
on
of no
March 5th, they
jurisdiction.
aided and abetted that.
Yes, because the underlying arson, there is no venue for to bring in an indictment in Fulton County. We could not bring that as a separate account because this court lacks, and this county lacks venue over it as an individual or a separate offense. So we couldn't include it as a separate count.
Okay, because the fire was in DeKalb.
Yes, sir. But our position.
That might be information that they would have wanted to know about. Of this thing got burned up in this place. You may be 100% correct. Can't bring it as a separate account because didn't happen here.
Yes, sir.
But it puts them on notice as to what they've got to defend against.
And Judge, the only thing that I can tell you is that I'm not going to sit here and argue that that more detail could be provided, that it couldn't be better or more perfect, if you will. What the state's position to the court is that there is no legal authority and there is no case law or precedent or persuasive case law that supports the position that us failing to identify which overt acts that are also included directly and specifically in our indictment as including racketeering activity, that by failing to delineate which are overt acts and predicate acts, there's no case law or authority that says that that is a demurrable flaw in the indictment. That's my
Sounds like no
position.
matter which way I rule, there's about to be case law on it.
It's possible,
One of you is going to take me across the street.
completely possible. So that is my position, Judge, and I do understand what the court is saying. I understand their argument. Why are you looking at me like that?
Just the brow is furrowed, that's all.
Okay. I didn't know if that had said something that you were questioning.
No.
So with regard to that issue about delineation and articulation, of which I think I've answered that.
Whose
Going-
alarm went off?
That was me.
$50, charity of your choice. Send me the receipt.
Supposed to take my son to climbing.
All these people have climbing gear. Gallows humor, y'all. Sorry about that. Go ahead.
Thank you, Judge. I just need to respond to a few more things. Hang on, let me make sure.
Before he has to go up to Stone Summit and.
Excuse me. I would never go stone somehow.
Go ahead.
Too much. I've already presented that to you. Okay, so there was arguments in the defense made that, for example, anything in claim in part one could be a predicate act, and Judge, I just quickly and bluntly, it just doesn't that lacks basis, because it's clearly delineated that it says, and the following are going to be, or alleged to be overt acts in furtherance of the conspiracy, and some include. Oh,
You're addressing their concern about do they know they're gonna have to defend against stuff coming in out of part one?
Yes, I'm sorry if I didn't say that
Uh,
well. But there was a lot of things said, and I'm trying to make sure I hit them without dwelling. So I'm trying to begin back at the beginning of their argument, and that is where they started essentially. And the point is that is very clear and is delineated in the indictment. When the allegations regarding overt acts, which include predicate acts of racketeering activity, begins, and that is the language that has been cited of, but it's
Okay,
Part two.
Let me read you the chunk of language before part one.
before part one?
Yep.
Yes, sir.
The end of, you got count one, racketeering. Lists all 61 folk. For said accused individually and as persons concerned in the commission of a crime and together with unindicted co-conspirators in the state of Georgia and the county of Fulton on or between May 25th, 2020 and August 25th, 2023, while associated with an enterprise, did unlawfully conspire and endeavor to conduct and participate in directly and indirectly such enterprise through a pattern of racketeering activity in violation of 1614-4B, as more particularly described below and incorporated by reference as if fully and set forth herein, contrary to the laws of the state of Georgia, good order, peace, dignity thereof. Part one, the enterprise.
Yes, sir.
So all the facts in the enterprise are incorporated into count one. You stand before me saying, hey, Judge, we're just talking about those 225 acts. I'll take you at your word. They can't. They got to take the indictment as written.
Which says introduction, the enterprise, and one of the elements we
It
must
says
prove.
part one, the enterprise.
And then it gives an.
A,
Yes.
introduction.
Yes.
B, defend the Atlanta forest.
Yes.
Anarchy background of defend the forest. Beginnings of defend the forest. Public Safety Training Center, Shadowbox Studios, Cab County, land swap. These all have facts in there,
Facts. Yes, sir.
okay? That defend the Atlanta forest overview. Defend the Atlanta forest funding. Now, then we run into the whole money laundering issue. Communication. Talking about Signal, Telegram. Entity amount totaled $48,000. Occupation inside. There are facts. And, yes, obviously we're going back to however many centuries. That's a little different than, hey, propaganda and recruitment. Are they going to have to defend against this?
Defend against it in the context of an overt act.
In the
No, it's
context
not
of,
lit.
is there an enterprise? Did they use these things to build an enterprise? Is there indeed an enterprise?
Then yes, Judge, any and all evidence we have at our disposal to establish and to show that this group of individuals were associated in fact, and that they had a common purpose to commit racketeering activities. Any admissible evidence to prove that, absolutely, they should be prepared to defend against it. If it's not admissible, the court will say that they don't have to defend against it. But as far as whether there was an enterprise, 100%, the defense should be prepared for every single fact that we can use to establish the association of this group of people, how they were funded, how they recruited, sure, we have to.
But
I mean,
none
we're
of that,
arguing.
none of that.
Yes, Judge, it is in there. Recruitment, well, let me let you finish your sentence. Excuse me.
I'm now into your 225.
Well, now that's a separate issue because all of that goes to the enterprise, and the indictment clearly delineates that part one, I think is how it says, under, so count one, elements of conspiracy, then part one, the enterprise. It is defining the enterprise, describing the enterprise, whether eloquently or with violent political rhetoric, depends on who you talk to. But regardless, the bottom line is, it is in fact, that is where the indictment says each individual charged in this indictment knowingly joined into the conspiracy contained a common purpose. So it fully lays out everything. And while I'm here, it also lays out the nexus. It affirmatively avers that, and I think I've said this, but I'll say it again, defendant in the Atlanta Force is a self-identified coalition and enterprise, blah, blah, blah. And that organization coordinates, advertises, conducts direct action designed to prevent the construction of those things and promote anarchist ideas. This self-proclaimed direct action has included, and then it lists the various things, vandalization of private property, arson, destruction of property, tax on law enforcement. Anyway, so the point is, while I'm there, that is the nexus. It affirmatively argues the nexus. And then we get to all of the other things that are alleged about it, the description, because we must prove and allege enough detail to establish the enterprise. And Mr. Fowler's already talked about why the history and things of that nature are.
So are they going to have to defend against masked folks making statements? That was raised by the defense.
If it's admissible, yes. And the state is going to say that some of those things are admissible. Yes, sir. If a co-conspirator that we can establish, our co-conspirators, produces propaganda that talks about different things about this conspiracy, and I know people threw out the confrontation clause, in no way is it testimonial, in no way. So if we can establish, because it's not testimonial, because it's not made, this is well before any type of arrest or prosecution. So there was no possibility that it was gathered for the purposes of litigation. If we can meet the elements of admissibility, that's the reality of it. But that's true of any situation, Judge. The state is going to use any and all fact that the state believes and can show furthers its proof of various facts in the case. And if those are admissible, yes, they should be. Now they're going to argue that they're not admissible. We will argue that they are, and the court will decide what comes in the end. But yes, any and every piece of evidence we have that establishes, well, for one thing, when it began, when the conspiracy started, when they started making plans, when they began the occupation of the forest, all of those things for the very reason of what we've been arguing about today, for one thing. It all becomes relevant.
All right.
So that is part one. And to go back to how they know that part one's not is because part two says it. Part two delineates and specifically says that they committed, you see it, the defendants committed overt acts to affect the object of the conspiracy, which include acts of racketeering as described below. So and this is no offense to anybody, but I think it's disingenuous to say that, or it ignores the language of the statute. Let me just say that, or the indictment itself, to say that we don't know whether or not the part one is also the overt acts and the predicate acts, because the indictment, while it could be better and it could specify which one of the overt acts are racketeering activity, definitely it could, and it doesn't. It does delineate what acts we are saying are or could be or they might have to defend against. And then when you look to the statute, it is further limited. Not every act is going to, for example, the money transfers. Those are overt acts in furtherance of the conspiracy, allegedly. That's what we say they are. However, that in no way falls within any definition. It doesn't fall within the statute. It's not an arson. I mean, it's not related to arson, or it's not related to murder or robbery, kidnapping. It's not an act or threat. It's not with one of the one of the crimes, I need to slow down, one of the crimes under the 5A. And so, no, I mean, but it does require that analysis. So the state's position, Judge, is what I've said. And then, as far as whether or not there are other aspects, one of the things that they have alleged is that we have not drawn enough, or we haven't alleged, and they say it in different ways, but one of the arguments is, and Mr. Samuel said it, and I think it's been said multiple times, is they don't even say for example, they don't say my client did an overt act, or did a predicate offense. He or she is not charged, it's not charged in this crime or that crime. And I'll just say, Judge, we don't have to allege or prove that. We'll go back to Mr. Liberto since he's been the star of the day, okay? That Mr. Liberto or any particular defendant charged in this indictment, we do not have to allege or prove that they ever committed a predicate act or that they ever agreed to commit a predicate act. And bear with me, Salinas v. State, and I know I should have briefed, Salinas versus United States. And that is 522.
Hold on.
And I do have a copy of any of these you want, Judge.
Nope. 522.
US 52. Figure out what page that is. 1 second, Judge. I need to correct you to the page. Some of these lines. Don't have it. Sorry, Judge, for the delay. Another yellow distinguished case. Just want to make sure I reference the correct page number. It's going to be. There. It's going to start, Judge, I think on 62. Get to the correct quote. If conspirators have a plan. I don't know the page number.
Okay.
So there's a portion of it, Judge, that quotes to United States v. Holt, and that's 236 U.S. 140. And the Salinas Supreme Court says, if conspirators have a plan which calls for some conspirators to perpetrate the crime and others to provide support, the supporters are as guilty as the perpetrators. As Justice Holmes observed, plainly, a person may conspire for the commission of a crime by a third person. A person, moreover, may be liable for a conspiracy even though he was incapable of committing the substantive offense. And that's citing to
Page
Rabinowitz.
60 I don't see that on page 62.
I may be on the wrong page. Let me find it. It's in here.
Conspiracy may exist even if a conspirator does not agree to commit or facilitate each and every part of the substantive offense. The partners in the criminal plan must agree to pursue the same criminal objective and may divide up the work. Each is responsible for the acts of the other.
Yes, sir.
If conspirators have a plan which calls for some conspirators to perpetrate the plan and others to provide support, the supporters are as guilty as the perpetrators.
Yes.
Finally, a person may conspire for the commission of a crime by a third person. Person, moreover, may be liable for conspiracy even though he was incapable of committing a substantive offense.
That's page 64, 63 to 64, Judge. So yes, sir, I apologize. And continuing on, in that same case, Judge, it rejects the concept. In fact, they argue in this case that we should have to prove that connection, that each perpetrator or each defendant, was required to have participated or intended to participate to engage in or commit racketeering activity. And the court directly rejected that. And let's see, on page 65, towards the bottom, it says a conspirator must intend to further an endeavor which, if completed, would satisfy all of the elements of a substantive criminal offense under the federal statute, which is different from ours. But it suffices that he adopt the goal of furthering or facilitating the criminal behavior. He may do so in any number of ways, short of agreeing to undertake all of the acts necessary for the crime's completion. One may be a conspirator by agreeing to facilitate only some acts leading to the substantive offense. It is elementary that the conspiracy may exist and be punished whether or not the substantive crime even ensues, because conspiracy is the distinct evil dangerous to the public. And this is where it, in the state's opinion, has particular pertinence to their argument. It says it makes no difference whether that the substantive offenses under the federal statute requires two or more predicate acts. The interplay between subsections C and D does not permit us to excuse, that's the conspiracy aspect of it, does not permit us to excuse from the reach of the conspiracy provision an actor who does not himself commit or agree to commit two or more predicate acts requisite to the underlying offense. So again, addressing the argument being that we had to allege in our indictment that the defendants either agreed to commit acts, predicate acts, or did commit predicate acts, that's incorrect. We do not have to make that accusation in the indictment. We do not have to allege that. We do not have to prove that. As long as they knowingly joined the conspiracy, and the conspiracy the conspiracy itself has the common purpose of committing racketeering activity. And I quoted that to you earlier, or cited that to you earlier. In addition, I cited Thompson v. State to you earlier, which also supplies further, makes the state's argument even more secure or more definite, because it does not require, that's the case, Judge, that if you recall, and this is an important thing, we don't even have to prove that they had every knowledge, were involved in everything, that they knew all the facets of it, that they knew what all of the co-conspirators were going to do. As stated, what we must prove is that they intended and knowingly joined the conspiracy, and that the conspiracy had the common purpose. And that's what we have to prove, and we have explicitly alleged that in paragraph A of the introduction. So as to that argument from the defense, it just doesn't pan out, Judge. They also argue that the criminal purpose to commit, that we have to allege and prove that the enterprise had a criminal purpose, and that I don't know how much this was fleshed out in oral argument, but I saw it in the written, that the enterprise must have a criminal purpose, and that's just not an accurate reflection of the law. The law that I have cited to you already and read in court already explains that an enterprise isn't a crime itself, and that it doesn't have to be criminal. I mean, the enterprise, this grouping of individuals associated in fact, can be, in fact, illicit or illicit. So, and their activities can be licit and illicit. So the enterprise itself does not have to be a criminal, does not have to have in other words, they have to have the common purpose of committing, we have to prove, and we have alleged.
Wait,
Yes,
illicit
sir.
versus illicit. Licit is, we've incorporated, defend Atlanta Forest, we are an enterprise. Illicit is, we're just a group of folks. There still has to be a criminal intent there.
Not in the joining, not, they have to have a common purpose. And yes, as a group, as an enterprise,
And as long as that common purpose is a legal, legitimate thing, that's okay, right?
until this group of associates conspires and determines to, or agrees to commit two or more predicate acts to reach their objective. Yes, then now we're getting into the RICO, and that's what's alleged.
So they commit criminal acts.
Yes. Yes, sir.
Okay.
Took me a minute to get there, but yes, sir. So I've already talked about the nexus. Already talked about that. If you'll give me 1 second, Judge, I want to make sure. There's a lot of there's a lot of argument, and I've read and I'm not going to go through every single one, but there is a lot of argument about there's not enough here, there's too much there, there's not enough here, there's not enough there. For example, night of rage, or whatever it may be. The reality of it is, Judge, we have to allege sufficiently the elements of the offense, which obviously for that last several hours I have been arguing that we have. We do not have to allege every fact that they want to know. We do not have to allege
Agreed.
how we are going to prove something. We do not. We allege the elements enough so that they understand what's coming against, or that the charges against them, and that's really the point, and the charges they are going to have to defend against. And then the discovery, it shows them the evidence we're going to use, how we're going to use and apply that evidence, what we're going to argue, what our internal mental thought processes are on prosecutors as to what evidence pertains to this and how we're going to prove that. That is simply not required in an indictment. And I'll give you an example, night of rage. They came down here for a night of rage. If we had gone into the definition and explanation and all the explanation about what a night of rage was, one, it would have no bearing on the fact that that was the overt act was alleged, that they came down on a night of rage, which the evidence will explain at trial, and they did X, Y, and Z. If we had gone through 15 paragraphs talking about this night of rage and where it came from and how we know they called it and all the calls to do it and all the things that different co-conspirators, named and unnamed, put out there on social media to stir up and stir violence, then we'd have been talking about political violence again, or rhetoric again. So it's not necessary. We made an allegation of an overt act in furtherance of the conspiracy, and that's what we did. And there's no more detail that they're entitled to on those type of issues. So, can't see without these. And Judge, I'll give you one last little example. I mean, I need to wrap it up, but the many things that they think they want to know are simply not required to be alleged in the indictment. I'll give you an example. criminal trespass, the term criminal trespass. It says that so-and-so did commit a criminal trespass. And there's a lot of motions filed and people arguing about that. He's not charged with criminal trespass. It's listed as an overt act. Criminal trespass is not one of the offenses under 1614.3.5A. So it's not a criminal offense. It's not a racketeering activity under B. And so it's simply a statement, okay? Now, that he committed this in furtherance of. Could it be more specific? Sure. But is he entitled, because we use those words, to a full recitation of the elements of the offense? The state says no, because he's not charged with the offense. If we were charging him with criminal trespass.
But you couldn't charge him with the offense because it happened in
Yes.
DeKalb County.
True, but we're not. So we have not alleged criminal trespass in our indictment as a crime. And therefore, and again, what we're talking about is what is demurrable or not, or whether the indictment is valid or not. And that is not a valid basis to invalidate the indictment in the context that he's not charged with it. So the requirements that we set forth, every element of it, just does not pertain. We generally said that he committed a criminal trespass. Now, they can argue whatever they want to the jury at that point, but that is one example. There are many others, but I think the court gets the gist of my argument, which is the details that are necessary, the details that define and prove or allege, not prove, allege with sufficient particularity that the all of the elements, and Mr. Garland did an excellent job of articulating those elements, that the indictment has done so, and that while it could be better, it is sufficient.
Okay. Your motion, Mr. Garland, you're up.
Okay. So even if we were to concede, which we don't, that the allegations of arson and domestic terrorism on January 21st satisfy general demurrer, that does not save this indictment from my special demurrer.
This
Or-
count,
What?
this count or this indictment?
Doesn't save that, even if that was enough to save the indictment from a general demurrer, it doesn't save it from a special demurrer. Because the special demurrer doesn't identify those predicate acts in any way. And it
Are
doesn't
we
tell us.
talking about counts 2, 3, 1?
Counsel, with respect to.
Mr. Schwartz, he's up.
Sorry.
Counts.
Judge.
You
After-
delineated him. He's your guy.
Yes, sir.
Yeah, no, I understand what you're saying, Your Honor. There's counts 2 through,
There's 2 and 3. There's 1, 2, and 3. That's all we
yeah,
got
so
left.
counts 2 and 3,
Uh-huh.
which allege arson and domestic terrorism.
Yep.
There's an argument under which those could.
Right now, we're talking about count 1 in this motion. In motion number 3,
Okay.
right?
I'll abandon that because it's not essential to what I'm trying to convey, is that this indictment fails a special demurrer. State v. Eastman tells us
Count 1, because that's the motion I'm looking at. Count 1
one of this indictment
does not
fails.
survive a special demur.
That's correct. And this is State v. Eastman, 911 Southeast 2nd, 484.
Hang on, I think I got Eastman.
It's a 2025 case.
Yeah.
By filing a special demurrer, the accused claims not that the charge in the indictment is fatally defective and incapable of supporting a conviction, as would be asserted by a general demurrer, but rather that the charge is imperfect as to form or that the accused is entitled to more information. That's what I'm focused on, Your Honor. The state, and the information we need is set out in OCGA 17-7-54 and by Kimbrough. We got to have the essential elements. It's got to allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And it must allow the defendant to prepare her defense intelligently. So They've got to allege that. They don't necessarily have to do it as a separate count in the indictment, but they've got to do it in the indictment. They can't get up here and argue that they're somehow met. It has to be in the indictment. They've got to allege the essential elements and the facts supporting them. And they fail to do that for many of the potential predicate acts that we've discussed today. Assault, influencing a witness, obstruction, money laundering, and whatever other predicate act the state can dream up.
Can you help me on the quote on the site for Eastman again?
Yes. 911, Southeast 2nd,
Give me the Georgia one.
okay, 374,
Uh-huh.
Georgia app,
Yep.
120. 120.
Oh, I wasn't even close.
Would you like me to pause, Your Honor?
Yeah, just for a
Okay.
minute, sorry.
And that's at page 121.
There we go. Okay, so you're saying, hey, these predicate acts that are criminal acts, I need my elements, et cetera, et cetera. Whereas I just heard from the state saying they're not charged with those. I don't have to give them the elements of them.
Well, I
Because they're
mean,
not charged with them because they happen in another jurisdiction.
I think that's a red herring, Your Honor. I mean, Kimbrough and OCGA 17-7-54 are clear. We've got to state the essential elements. We've got to establish the underlying facts, right? It's required by Georgia law. It doesn't have to be in a separate count. It could be in the overt acts themselves. They could set out the essential elements. It could set out the essential facts, but they don't do that, Your Honor. They don't do it for assault, influencing a witness, obstruction, money laundering, and whatever else they can dream up. The discussion of Dorsey and these 5B acts, it's not a red herring, but they're putting the emphasis on the wrong syllable in that case. These 5B acts are acts involving murder, kidnapping, gambling, arson, robbery, theft, so on and so forth. The list of crimes listed in 5B that could involve predicate acts involving those crimes. But Dorsey's interpretation of 5B is really just about how we count the predicate acts. It talks about the acts involving style of predicate acts can be their own separate predicate acts. So a series of acts involving another crime can all be separate predicate acts, right? So in Dorsey, you've got the murder, right? That's one act. But then getting in the car, that's another act. Buying the gun, that's another act. These are all predicate acts under 5B. But what Dorsey has that this indictment fails is an allegation of the essential elements of the murder. Is an allegation of the essential facts supporting those elements, right? Dorsey is like, how many predicate acts are there in a murder, Judge? Well, we've got the murder and then we've got the other acts involving it. But got that murder. It's alleged. The essential elements are alleged and the facts supporting are alleged. We've got it, right, in the case. How do we chop it up? That's what Dorsey's about. Here, we don't have the essential elements. We don't have the facts. There's nothing to chop up. We don't know what these acts are involving. They haven't identified them. They haven't set out the elements as required. They haven't set out the facts supporting it. So Dorsey is not a problem for this demurrer. Had my complaint been there's too many predicate acts, well, then Dorsey would be a problem for us. But that's not my complaint, is that they haven't sufficiently alleged the predicate acts at all. And they clearly did that in Dorsey without a problem. They established elements, they put the elements of murder in and the facts supporting them. So it provides no problem for our special demurrer. There was some discussion by the state about the allegations in part one of the enterprise. I've already discussed how it's both overbroad and lacks sufficient details, but as we've discussed, are those allegations of predicate acts because they're specifically incorporated into the overt acts that include the racketeering acts per the indictment? Does it include George Floyd? Does it include Rayshard Brooks? Does it include the masked man was he involved in an act involving felony obstruction? We don't know. We can't know. The indictment doesn't tell us. And in regards, let's see. And there are certainly things that this indictment doesn't allege that I'd want to know. And it doesn't have to allege everything I want to know, Judge. But it's got to get across some fundamental threshold so I can prepare a defense for my client. This indictment is a problem of the state's creation. It suffers as a result of how they drafted and indicted it. Georgia law prevents my client and all the other co-defendants from having to fight for their liberty based on an unintelligible indictment. And we ask Your Honor to grant this special demurrer.
Okay. All right, ladies and gentlemen.